Yep.
All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, January 31st, 2024. We have 14 bills on the docket, and we're going to start off with Senator Benson, who's here joining us with Senate Bill 410. We're then going to move on to Senate Bill 557, 155, 153, 60, 68, 10, 63, 316, 357, 42, 149, 77, and then we'll end up with Senate Bill 55. Senator Benson, welcome back to JPR. You are up. Can we grab her mic? Thanks.
Good afternoon, Mr. Chair, and my fellow esteemed members of the Budget and Taxation.
How could you forget us? We're JPR, you know. You love us so much. You know?
I know that's right. Good afternoon, Chairman Guzzoni. What is wrong with me today? Good afternoon, Mr. Chair and esteemed members of the Judiciary Committee. Today, I wish to address you on the vehicle registration plate prohibition before us as Senate Bill 410. This prohibition prohibits any person from displaying any vehicle registration plate that is neither one, lawfully issued, or two, legally used on or for the vehicle under its title. Further, no one may knowingly display or use, possess, or purchase for any vehicle any registration plate that isn't legally attached to the vehicle. Therefore, any person convicted in violation of this statute is subject to up to 90 days of imprisonment or a fine of $10,000. This bill deters the knowledgeable display, use, possession, or purchase of unauthorized registration plates for any vehicle. Beyond the plain sense of this measure is its potential pecuniary benefit. A previous fiscal note provided by the Department of Legislative Services of directly related legislation, but from a prior year, provides that just in proper enforcement of merely maintaining the display of front and rear tags, Maryland stands to benefit at least $1 million per year. Even without the financial benefit, common sense prevails. While it is unconstitutional to say that one has the propensity to commit a crime because of certain behaviors, we can draw strong correlations. One which is plain to me here today is that those likely to engage in behaviors whereby they find themselves knowingly possessing, using, or displaying illegal plates on or for a vehicle are likely up to no good. Thus, it is not only in our interest, but in fact, our responsibility to support and motivate the enactment of this seemingly small piece of legislation. Let us and this committee give its weight, the weight it deserves, with a truly resolved report in favor of Senate Bill 410, Vehicle Laws, Unauthorized Registration Plates Prohibition. It may be 2024, but like 100 years before, in this committee, a member claims, but with good reason, prohibition. Thus, I respectfully urge the committee to issue a favorable report for Senate Bill 410. Thank you, Mr. Chair and members of the committee.
Excellent. Thank you very much, Senator. Questions from the committee? Seeing none, that'll conclude the hearing for Senate Bill 410. Thank you very much, Senator.
Thank you.
Good to see you. All right, we are going to take just a quick pause. We're going to call Senate Bill 575 next, but we're going to just take a quick pause.
I think they might be out there.
Okay. You can tell, Chief Judge, you can tell them just take their time. We'll wait. Chief Justice, my apologies. Supreme Court of Maryland. Get it right. We did that here, so I should probably know that.
Need another couple minutes.
Excellent. All right, welcome back. Welcome, Senator Quarterman. Thank you for bringing the bill forward. And today we're joined by several distinguished members of the judicial branch, and then obviously Judge Wilkinson's family. Appreciate you being here and taking the time to testify before the Judicial Proceedings Committee. We'll now hear from Senator Quarterman with Senate Bill 557. Before you begin your remarks, though, I want to emphasize that this piece of legislation is a priority for our committee, as it was last year, and just because of the unpredictability of the legislative process and the arduousness of the legislative process, we were unable to get it done, but we're committed to getting it done this year. So I really appreciate you all coming back, and appreciate you being here with us. And Senator, thank you for bringing the legislation forward. So the floor is yours.
Thank you. Thank you, Chair. Chair Smith, Vice Chair Wallstriker, members of the Judicial Proceedings Committee. Thank you for the opportunity this afternoon to present Senate Bill 575, Court Personnel Protection of Personal Information, the Judge Andrew F. Wilkinson Judicial Security Act. For the record, I'm Senator Paul Quarterman, representing District 2, Washington and Frederick counties. Nearly 10 months ago, I stood on the Senate floor and relayed the challenges and experiences that my family had suffered through as our father, then a circuit court judge of Washington County, encountered multiple threats throughout his judicial career, most notably as the recipient of 4 pipe bombs, 3 of which detonated inside his residence by opening a package bomb that was sent to him. It is beyond comprehension how this type of targeted hate can be inflicted upon a specific group of public servants and their families, not only in the same state, but in the same local community. In October of 2023, the Washington County community, along with the state of Maryland, and most notably the Wilkinson family, suffered an unimaginable tragedy when Circuit Court Judge Andrew F. Wilkinson was murdered in the driveway of his own home. Left behind is his family, which many are joined here with us today, including his beloved wife, Stephanie, along with their children, Carolyn and Grant. This vicious attack on a member of the Maryland judiciary leaves an indelible mark, not only in our local community, but throughout the entire state of Maryland and our country. As such, it warrants immediate action to protect not only the state's judicial officers, but also their families, and the hope that a similar incident can be avoided in the future. Senate Bill 575 authorizes the Office of Informational Privacy and Administrative Office of the Courts to request that a government entity or a person not publish personal information of certain protected individuals on the internet, social media, or social networks. Additionally, the bill provides a process of removing existing personal information that is displayed on the internet, social media, or social networks. If that information is requested and to be removed and it is not, there are civil and potential criminal penalties for the offending party. Members of the Maryland judiciary serve because they care deeply about their communities and about our state, despite the additional safety risks to them and their families associated with their role. As legislators, it is our obligation to support legislation that protects them both and their families from the most harmful of situations. These threats are real. They happen to real people. They've happened in our state, and they happen and affect the families of the judicial officers who serve our communities. I'd like to thank the committee for your consideration today. Respectfully ask a favorable report on Senate Bill 575, the Judge Andrew F. Wilkinson Judicial Security Act. I'm going to pass it on to Chief Judge Fader, who will speak more to the specifics and the merits of the bill. Thank you.
Good afternoon, Chair Smith, members of the committee. Thank you, Senator Quarterman. I do want to make sure we have Judge Esther Salas, who was in the Zoom waiting room. I don't know if she's been let in. Okay, thank you. Thank you very much for the opportunity to testify here today in support of the Judge Andrew F. Wilkinson Judicial Security Act. Thank you also for taking this bill up at this time. I'm honored to be joined here today by Stephanie Wilkinson, the wife of the late Andrew F. Wilkinson, by Chief Judge James K. Berdar of the United States District Court for the District of Maryland. And I'm also honored to be joined remotely by Judge Esther Salas of the United States District Court for the District of New Jersey. Also present here today are a number of leaders of the Maryland judiciary, including Chief Judge E. Gregory Wells of the Appellate Court of Maryland, Judge Audrey Carrion, Chair of the Conference of Circuit Court Judges and Administrative Judge of the Circuit Court for Baltimore City, Chief Judge John P. Morrissey of the District Court of Maryland, Judge Brett R. Wilson, Administrative Judge of the Circuit Court of Washington County, and Judy Roop, State Court Administrator. The reason we are here is not a pleasant one. We are not here for grace or favors. We're not here because judicial officers are more deserving of protection than anyone else. That's not the case. We are here because judicial officers, whose positions represent the very embodiment of our government's commitment to the rule of law, are in real danger, as are their families, from the ease of access to their personally identifiable information from publicly available sources, especially over the internet. This is not a new problem, nor is it a theoretical problem, as we unfortunately know all too well. You'll hear today about two specific incidents of violence targeted at judicial officers. In one, Judge Drew Wilkinson was murdered last October after he did exactly what I'm sure every member of this committee thought was his job to do. He removed custody from a father who he had concluded was a danger to his children. Judge Wilkinson followed the law. He protected those children. But because the murderer was able to find out where Judge Wilkinson lived, Judge Wilkinson paid with his life for doing his job. Judges and magistrates across the state of Maryland have to make exactly that same decision many times every day. They deserve to do it without fear of paying the same price that Judge Wilkinson paid and that his family continues to pay. You will also hear from Judge Salas, whose son Daniel was murdered and whose husband was shot by a man who found his way to her house to exact his rage because she did her job. And apparently because he didn't like that someone like her was in a position to do that job. Judges, magistrates, and commissioners across the state have to make difficult decisions about people's liberty and rights every day. And they deserve to do it without fear that their family members will pay the same price that Judge Salas's son paid and that Judge Salas and her family continue to pay. The Judge Andrew F. Wilkinson Judicial Security Act is a limited bill intended to protect judicial officers and their families by making it harder for those who would take vengeance against the judicial officers for their decisions to find them where they are most vulnerable. It has three primary components. First, the bill identifies specific types of personally identifiable information that is protected from disclosure on the internet by private and government entities. This includes home addresses and previously unpublished phone numbers. It also protects other sensitive information that could lead someone to the judicial officers or their family members, such as their license plates and social security numbers or where their children go to school. The act requires removal of that information from the internet upon request. If the entity refuses, it allows a lawsuit to compel that to happen, and for private entities, damages. I note that the definition of personally identifiable information in the bill includes two important carve-outs. One is for information that the individual has previously made public with their consent, and the second is for information that is a matter of public concern. The types of information that are covered by this law will rarely be matters of public concern, but where they are protected and can be disclosed. There's also a provision providing criminal penalties where someone posts information knowing that substantial harm is likely to result and where that does in fact lead to criminal actions. Second, the bill creates an address confidentiality program where concerns require greater protection than just removal from the internet. This provision allows covered individuals to use an alternate address in other records, including paper records. An individual with a legitimate business need can still get access to that information, such as for title research purposes, for example, as can individuals pursuing a matter of public concern. In those situations, notice would be provided to the officer. Third, the bill attempts to address different, but no less important, safety concerns by creating a task force to study specific safety issues at many of our courthouses, especially in our circuit courts. Unlike the district court and appellate courts, as this committee is certainly aware, our circuit courts are not part of a unified court system. As a result, security in those courts is provided not by the judiciary, but by sheriffs in each county and Baltimore City. And budgets for security and related building issues are provided not by the judiciary, but by legislative bodies in each county and in Baltimore City. The result of that, combined with the ongoing difficulties in hiring law enforcement personnel across the state and the country, have been gaps in security in some places. And I do not mean at all to suggest that security personnel are not doing their best. They are. There are many individuals who provide outstanding service to protect our courthouses and our court personnel across the state, and we are deeply appreciative of that. However, in some of our largest jurisdictions, just by way of example, there's not enough security to have officers in courtrooms other than in criminal cases. Guidance coming from the National Center for State Courts relating to judicial security tells judicial officers not to enter their courtrooms unless there is a court security officer present. And yet Maryland judicial officers do so in some of our largest jurisdictions and in some of the most contentious cases judges hear every day. There's also an absence of secured parking for many judicial officers and a lack of security getting to and from public parking areas. In Baltimore City, for example, more than a third of active judges park in public areas and walk by themselves to and from the courthouse, past some of the same people who will be or were before them in court that day. And in some jurisdictions, judges walk in and out of the front door of the courthouse and park on the street. This bill would create a broad task force to study standards for those issues and to recommend legislation to address them in consideration in next year's legislative session. I'll note that the Maryland State Bar Association will be testifying, and I understand there will be a request to add a member of the MSBA to that task force. That's actually something we had intended and do support, for the record. Attacks on judicial officers are increasing. The dramatic rise in verbal attacks on judges in political discourse, especially at the national level, has consequences for the physical safety of judges and their families. Threats to judges in Maryland have increased since Judge Wilkinson's assassination. During the week-long educational course for new judges that we hold every year, which we affectionately refer to as Baby Judge School, I tell new judges that the rule of law protects each and every citizen in this state. I then tell them that they, as judges, now protect the rule of law. The people of the Maryland judiciary and the federal judiciary in Maryland stand up for the people of this state every day. They should be able to do so without unnecessary and unproductive risk to themselves and their families. This bill is intended to help realize that goal. I appreciate your consideration and your support for this important legislation, and I look forward to your questions. And I will now turn it over to Chief Judge Berdar.
Chairperson Smith, members of this committee, good afternoon. My name is James K. Berdar. I serve as the Chief Judge of the United States District Court for the District of Maryland. I've been a federal judicial officer since 1998. I appear today on behalf of my colleagues serving as United States Circuit Judges, District Judges, Magistrate Judges, and Bankruptcy Judges here in Maryland. Altogether, there are 33 of us. Legislators such as yourselves, before all others, understand that the United States is a nation of laws. It's the rule of law that ensures that the public is safe, that commerce can occur efficiently and reliably, and that the rights and liberties of all are respected and protected. And of course, it is judges who enforce the rule of law. Accordingly, if judges are not safe, then the rule of law is not safe. And there's ample evidence that judges increasingly are not safe. Apart from the horrible attacks visited upon the Wilkinson and Salas families, with which we're all so terribly familiar, the United States Marshal Service reports that they investigated over 4,500 threats and inappropriate communications made against federal judicial officials during 2021, the last year for which they have data. A significant number of those were against judges right here in Maryland. Every time a case proceeds to a hearing or a trial before a judge, somebody loses. While the vast majority of citizens who lose their cases in court accept that outcome and move on with their lives, An ever-growing segment does not. And some portion of that segment descends into the business of planning reprisals against the judicial officers they blame for their lack of success. This phenomenon is growing. My colleagues and I, who serve in the federal judiciary in Maryland, now come before you and urge you to pass the Judge Andrew F. Wilkinson Judicial Security Act. As you may be aware, federal judges already enjoy some protection of their personal identifying information as a result of federal legislation. But the federal law only protects judges with respect to their information that is stored or traded by commercial entities. There's no protection in federal law for judges' personal and private information that is stored in governmental repositories. But the bill you have under consideration, if passed, would fill this critical gap in our lines of defense. The legislation before you would protect judges' most sensitive personal information now stored openly by state government, including our deeds and land records for our homes. We live in a time when two phenomena are intersecting: an increasing disposition to harm judicial officers when they rule against litigants, and a time when personal information such as home addresses can be acquired quickly with just a few clicks on a computer. If you enact the Judge Wilkinson judicial security legislation, you will not only be acting to support and protect your colleagues in the judicial branch of government, but you will be acting to ensure that this remains a state and nation governed by the rule of law. The stakes are no less than this. I too would be willing and happy to answer your questions. Thank you for hearing me.
So we'll now hear from Judge Salas.
Yes.
Excellent.
Good afternoon. Before I begin my testimony, I'd like to thank the committee for this opportunity to testify this afternoon. Despite the passage of time, the murder of our only child, Daniel, continues to create much agony and pain for Mark and for me. I can't describe it with mere words. But I want to take a little time just to set the stage of a day that I and my husband will never forget. On July 19, 2020, after celebrating a glorious weekend birthday celebration with our son Daniel and his friends from college, a lawyer at 5 o'clock on a beautiful Sunday afternoon came to my doorbell, came to my home, rang the doorbell, and took the life of our only child, Daniel. Daniel was shot point blank in the chest. He fell back with his arms in a cross position. And this shooter wasn't satisfied with that. He turned the gun on my husband of 29 years. And as Mark tried to get at the shooter, he just kept shooting my husband. One shot after another shot after another shot. In total, Mark was shot 3 times. 5 different parts of his body were affected. And I almost lost the only man I've ever loved 3 separate times after the shooting. It was a dreadful day. And it's one that I continue to try to move forward from, never on. We don't move on from these things. We only move forward. And like this tragedy and the tragedy that Maryland has suffered, and I say Maryland because all of its citizens suffered the day Judge Wilkinson was assassinated in front of his home. But as Stephanie and as I know, and as Carolyn and Grant know, that we have to make sure that our loved ones' lives are never in vain. And that's why we're here today. We're here today to ensure that we do our part to impress upon the Maryland legislature the need to protect all judges from fear of reprisal, retribution, or death. We have to be proactive in addressing these challenges that judicial officers face. Listen, when evil comes to get you, it comes to get you and you don't see it coming. Judge Wilkinson didn't see it coming. I didn't see it coming. We have to be proactive and take the necessary steps to guard our personally identifiable information. We are talking about preserving democracy here. When we have seen democracies toppled, who have they gone after? In Hungary, Venezuela, Nazi Germany, they went after the judges. We are under attack, and we need your help. We need your help to ensure that this type of tragedy never happens again. But if we don't do something to protect our personally identifiable information, this will not be the last tragedy. Stephanie Wilkinson will not be the last widow. So as I end my remarks today, I want to urge the Maryland legislature and the Senate to pass Senate Bill 575, Judge Andrew F. Wilkinson's Judicial Security Act. My son gave his life for his father and me. I know that. I know that. I know that Daniel stood with his arms out to block that shooter. And it took bravery and courage. And it will take bravery and courage for the Maryland legislature to do the right thing. And I ask you to please do the right thing. God bless, and thank you for this opportunity.
Thank you very much, Judge Salas. Would Ms. Wilkinson like to speak?
So, thank you. Okay. So, good afternoon, Chair Smith and members of the Judicial Proceedings Committee. My name is Stephanie Wilkinson. I am the surviving spouse of Judge Andrew F. Wilkinson. We know that in July 2023, a defendant in a domestic case began searching for my husband on the internet. We also know that on October 19th, 2023, that man no longer had to search for Drew because the internet easily led him to our home. While stalking our home, he was able to ambush my husband moments after he stepped outside to take a walk. I tried to tell myself that my husband did not suffer that night. But in reality, my heart is shattered when I think Drew's last feeling on earth was fear. Watch me closely. My husband was downed by one bullet, a 1/4 inch off center. And the stifling from the other bullet tells us it was a vengeful final blow. This was a close contact assassination by a disgruntled defendant who hated our judicial system and took it out on the judge in his case. My family is the victim of an attack on a cornerstone of our country, our judicial process. If we do not step in and offer our judiciary the protection and the privacy they should have, we will surely water down the strength of the judicial system by getting less qualified candidates to fill those positions. There are companies out there like LexisNexis who have programs that can do specifically what we need. Please meet with those professionals and let them explain to you how they can help. In closing today, I'm devastated that I lost my husband, but my heart is beyond repair that my children have lost their father. Please help make things right by supporting this bill. By doing so, you will assure my children and the children Drew saved that day in this domestic case that he did not die in vain. And that's all I have for you today. I do appreciate all of you guys taking the time to listen to all of us. And if you do have questions, please feel free to ask. Thank you.
Thank you very much, Ms. Wilkinson, and thank you to the entire panel. Thank you, Judge Salas, and in particular, Ms. Wilkinson, for coming before us today and reliving, in essence, the worst moments of your life to affect legislative change. So we really do appreciate you all being here. With that, I would like to turn it over to the committee for any comments or questions you may have for the panel. And we'll start off with Senator Sidnor.
Thank you very much, Mr. Chair. Ms. Wilkinson, sorry for your loss. I'm not certain if, let me see it. I'm not certain if I should be, I'm not going to ask for the sponsor, but if Chief, if I might ask, since I know you had a lot to do with the drafting of the legislation, and I spoke with Senator Quarterman the other day about this specific section. So I don't know, did you share the question?
No, I'm not.
Okay. So on page 7, section or proposed section 3-2304, lines 3 through 13, there is essentially a misdemeanor crime that's created, and it says a person may not knowingly publish the personal information of a protected individual if, and it says, if one, the person knows or reasonably should know that publishing the personal information poses an imminent and serious threat to the protected individual, and second part is the publishing of that personal information results in an assault in any degree, harassment, trespass, or malicious destruction of property. Is something missing in the drafting of that in the drafting of this particular portion of the legislation?
Not that I'm aware of, but if
Okay.
you point to something, I can comment on it perhaps.
Sure. Well, when I read this, I'm thinking I publish information. And the second piece of it is it results in something. I can publish something without knowing that this result is going to happen. It almost seemed as if when I read it, I'm thinking this is some sort of future crime type thing. It seemed like there was a step missing. And I know when I spoke with the sponsor of the legislation, he was saying that it was his understanding that it was a thing of I publish, you all contact me, and then if I don't take it down and this stuff happens, then it's a crime.
If I may, the situation that so this is if you publish something knowing or reasonably should know that it is likely to result in this. So this is the situation, for example, where we've seen in some cases where somebody puts something online and says, these judicial officers are doing something I don't like, go get them. And then somebody reads that and goes and gets them. You don't get absolved from responsibility in that just because you weren't the person who went out and got them, if you were the one who intentionally pointed them in that direction. That's the kind of conduct that we're looking at here.
Okay. And under this particular statute, okay. Because the other question that I'd had about that is who a person might encompass. So it's not necessarily just the individual, but if I remember correctly, most interpretation, a person could be an individual, it could be a company, it could be the publisher of the website. So again, I'm trying to flesh out what it is that you all are attempting to get at with this.
It like I said, it's somebody who does this knowing that substantial harm is likely to result. This is not a person who innocently posts something and then somebody happens to use it for a nefarious purpose that they weren't or shouldn't have been aware of. The things where it's happened to doctors in the past who have been performing procedures that some people don't like, where they've put up information about where the doctors live or other personal information that people can use in order to target them. That's who this is directed to. It's not, this is not the person who posts something without having any idea that other people are going to use it for a nefarious purpose. This is when somebody publishes something and they either know or should know that they're doing it in a way that's likely to lead to substantial harm.
Understand the intent. I know, I guess my read of it is much broader than just that incident. So, thank you very much.
Thank you, Mr. Chair. Thank you for bringing the bill, Senator Quarterman. Good to see you, Judge Bradar and Judge Fader. I think I speak for all of us, Ms. Wilkinson, when I expressed my condolences and deep sympathy for what happened. We live in really, really interesting and changing times. And I think that we are all interested in figuring out how to strike a balance between privacy and transparency to try to bring needed relief without possibly crossing lines. My question is more, and I apologize because I was late, so it could have been discussed before I got here, more about the mechanics of how it would work in terms of, is this just about like what Senator Sidnor sort of described, that someone intentionally posts this information, or with this office, the office that's created, have the responsibility of reaching out to all entities, like ensuring that even if a judge has a personal matter that's on case search, that's shielded, and these entities that crop up on like the internet, like Google, like we can all find anybody on Real People Search and People Finder. Would that be the responsibility to ensure that this personal information was shielded from all of those entities? Is that the plan?
I'll let Chief Judge speak to the specifics.
Yeah, so the first part of it does, with respect to government entities and private entities, the data brokers that you have, would allow a judicial officer, a protected individual, to request that their information that falls into the categories of protected information be removed. So they need to make the request. It's not something that exists as a responsibility of those entities without a request, but the request could come from the individual themselves or the Office of Information Privacy and the Administrative Office of the Courts, and then there would be an obligation to take those categories of information off of the internet.
Thank you. It seems like it's a really voluminous task because there's so many different second and third party entities that pop up that have this information. You can almost find anything about anybody. I know because I spent a lot of time looking for information, and it's easily accessible. Then my second question is really not so much related to the bill, but related to overall privacy, and it might be better directed to Judge Morrissey or someone at the district court. But I'm going to put it out there, and if anyone wants to answer it, that's fine. You're going to say it's not this bill, but there is an issue that has popped up since the killing of Judge Wilkinson, which is that attorneys that regularly practice in the state district court often determine their actions based upon information as to what judge will be sitting in the courtroom when they go to trial. And it's been my experience that since the murder of Judge Wilkinson, all the district court clerks have been advised, and it's only really primarily district court, because in circuit court, you have a set judge in a set courtroom and you have a scheduling order and you generally know who's going to be there. But in the district court, there's more rotation and it's luck of the draw. It's more random. Judges move around. And so I've been advised multiple times by multiple clerk houses that ever since this, they are no longer allowed to give out that information. But it's difficult because oftentimes that's how you advise your client how to proceed. It's how you make a determination as to whether you're going to pray a jury trial or go to trial or take a plea or do a postponement. But without knowing what judge is going to be there, it's extremely difficult to plan ahead. And so my request would be that as we move down this road in terms of creating more privacy, which I agree with, that we would try to ensure maybe even in the secret system or in the MDEC system or something that attorneys could still have access to know what judge might be presiding there. You might need to get a message to the court. And it's really, I think, would become more burdensome to continue to not be able to have that information. What do you think about that?
I'm not familiar with that issue, and I think we can look into it and maybe get back to you separately. But I think you correctly said this bill does not implicate that at all. But I think we understand and can look into that.
And again, I'm asking, and this is a clarification kind of a question. Page 3, within the definition of personal information, one of those pieces is a place of employment. While I understand that if we're talking in context of a judge's family members, I wonder, there's certainly been an action that's been reported in the Daily Record regarding one of our judges in the system. And if I'm not mistaken, it talks about where that judge is located and where they sit. Under a strict reading of this legislation, the newspaper wouldn't be allowed to, or no one will be able to allow to say that they work at this specific circuit court branch, correct? And I'm assuming that's not the intent.
You're right that that's not in the intent. That was called to our attention a couple of days ago, and that should be corrected. And probably to say a place of employment of an individual identified in section E6, so that it's limited to the spouse, child, or dependent. You're right. It's certainly not intended to preclude the notification that I work in the Murphy building or something like that.
Thank you very much.
Further questions from the committee? Senator Carter, thank you very much for those questions. Thank you all very much. We'll now hear from the next panel.
Thank you.
So we'd like to hear from Mr. Fullerton, and then we'll move on to Judge O'Malley. And then the next panel is favorable with amendments. Floor is yours.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is Kim Fullerton. I am a legislative liaison with the MSBA. I'm also a professor at University of Maryland School of Law, and I facilitate international delegations for the education of judges and legal scholars. I want to first address how very serious this issue is. We cannot underestimate what a global problem attacks on judges is. The DOJ has noted that threats to judges have increased dramatically over the past few years. So we must acknowledge the gravity of this threat. It is an immediate and specific danger. It destabilizes our democracy. It undermines public faith in the court system. Leaders in government are being targeted and assassinated because of their public service. This is a travesty. This is abhorrent to the rule of law, abhorrent to our Constitution. We have a duty to protect judges from this known threat. We need them to be free from pressure, free from influence. We need people to feel confidence that judges can make impartial decisions in their cases. We need people to trust that their case will be decided according to the law and the facts. Again, we have a duty to secure our government from this threat. We must establish an effective protocol to protect the third branch of government from this immediate danger. Thank you.
Good afternoon. Thank you, Chairman Smith and Vice Chair Waldstreicher. Thank you to Stephanie Wilkinson and her family for being here and describing to all of us the travesty that happened to her family this past fall. As well as esteemed members of this committee, thank you for having me here. I appreciate the opportunity to testify in full support of Senate Bill 575, the Judge Andrew F. Wilkinson Judicial Security Act. For over 20 years, I was honored to serve as a member of the Maryland Judiciary. Although I never had the privilege to work with Judge Wilkinson or to even meet him, I know many judges that have, and they all have had the utmost respect for him, for his work and his work ethic. My new position is as the Executive Director of the Women's Law Center of Maryland. The Women's Law Center handles thousands of cases annually that involve allegations of intimate partner violence. A large portion of our clients are seeking orders of protection from domestic violence. Also, a number of our clients are victims of second-degree assault, which are mainly district court matters and circuit court. Many of the judicial officers that preside over these contentious matters have been subjects to threats of violence against their safety and the safety of their families. And this has increased just since last year, sadly, as the death has occurred of Judge Wilkinson. The intent of this bill is to seek the safety and security of judicial officers and their families throughout the state of Maryland so that there will never be another tragedy like the one Judge Wilkinson's family and our judicial community, as well as the entire state of Maryland, experienced last October. We really urge at the Women's Law Center and now as their executive director that there be a favorable report on Senate Bill 575, and I'm happy to answer any questions of this esteemed committee. Thank you so much for your time.
Good afternoon, Chairman Smith, members of the Judicial Committee. My name is Jason Deloach, and I am the current president of the Maryland State Bar Association. The Maryland State Bar Association represents thousands of attorneys and legal professionals across the state. The Maryland State Bar Association recognizes the critical role that this legislation will take in keeping the critical steps across the litigation process to make sure that litigants and lawyers have a very good understanding that they're going to have their case determined solely on the facts and nothing else. The climate of today is making this be very difficult, and our members understand this, and they are urging that we get this legislation passed. So we're here in full support of this legislation. Now, the role of the judiciary is critical. The judge, the juries, they determine what happens in these cases and how people are addressed and how facts and issues are addressed. Any deterioration in the formal process and any deterioration in the citizens of respecting the judiciary, it has a tail to it that does not end. It is critical that our judicial panels, that our lawyers, our members of our MSBA are protected and they feel as though they can do their jobs without a problem. The judiciary serves a vital function of upholding the rule of law and serving as a pillar of our democracy. While other government and public officials may also face threats of violence and physical harm, the judiciary deserves the specific protection in this bill in order to preserve judicial integrity, permitting judges to make impartial decisions without fear of violent threats and harmful physical recourse. As Justice Fader indicated, we are looking for a friendly amendment to this bill as far as the task force is concerned, so that the MSBA can have a seat at the table to make sure that the process is moving forward, not only with the judiciary in mind, but as I'm sure the judiciary, as they said, they are in support of it, that our members have a seat at the table. This is very, very important for our legal process and the legal community. MSBA asks for this friendly amendment, and every judicial officer in the state must be able to decide cases without fear of reprisal. And unfortunately, we see in the national media today that this is something that is happening more and more. There's more agitation, there's more fury that's generated to judges. I've been practicing law for 25 years and I've never seen it like this. When you walk into a courtroom, and I'm a litigator, when you walk into a courtroom, you respect that judge. That's what you're told from law school up until you become a lawyer. And that is deteriorating now. We see it on social media. We see it on the news. We have very high profile litigants who have absolutely no respect for the judiciary. And as a result of that, we're seeing what we're seeing. It is foreseeable as we sit here today, it is foreseeable that another tragedy can happen. It's foreseeable. Last year, we were in the same position, but we did not have the stark reminder that we have in the form of Judge Wilkins. We have it here today. And I know you handled your business last time. It came out of this chamber. We have to get it over the finish line. It's not enough to name a courthouse after Judge Wilkinson. It's not enough to hang a plaque on the wall. As many of the members said earlier, the panel, we need substantive change to make sure that the judges who have been slain have not perished in vain. We need substantive change. We testify in full support of this bill and be more than happy to answer any questions. Thank you.
Thank you very much, Mr. Deloach. Questions from the committee? All right, seeing, Senator James has a question. Senator James.
I apologize for not being in the room when this hearing started. So I just wanted to say that one thing. Two, I completely agree with you that it was foreseeable last year, as well as it's being foreseeable this year. So I really just want to extend my apologies and say that I fully support this and I appreciate the testimony in the hearing. Thank you.
Thank you very much, Senator James, for saying that. No further questions from the committee. Thank you all very much for joining us today. That'll conclude the testimony for the proponents bill. We have favorable with amendments from our public defender, Natasha Dartig. Before our distinguished public defender comes up, I just want to reiterate, we are in receipt of the two amendments, which were considered to be friendly and a technical amendment. We're going to convene a work group and we are going to vote on this bill on Friday. We know that it didn't make it out of both chambers, but again, that's because of the process and the unpredictable nature of the legislative process, which is the arduous nature of our process. And so we look forward to working in collaboration with the House this year to get it done.
Good afternoon, Chairman Smith, members of the committee. I am Natasha Dartig, Maryland State Public Defender. The Maryland Office of the Public Defender is here in support of Senate Bill 575, and we are urging a favorable report, however, requesting a friendly amendment, and essentially that the provision that establishes a task force, we ask that the Maryland Office of the Public Defender be included as a member. Senate Bill 575 will serve to protect and increase the security of current and retired judges, justices, magistrates, and their families. The need for this law is unfortunate, but long overdue. We ask for a favorable report and especially make note of this amendment. As public defender, I am charged with many responsibilities, including managing threat responses and ensuring the safety of all employees, especially the assistant public defenders that serve in courtrooms throughout the state of Maryland. Public service, especially those who work in the legal system, is incredibly important, and we face unique risks to our safety and the safety of families. Throughout Maryland, we have seen judges, but also public defenders and prosecutors who have been threatened with doxing, invasion of privacy, and physical harm. No public servant should fear their safety solely based upon the jobs that they hold. We urge the committee to add the Maryland Office of the Public Defender as a member of the task force and issue a favorable report to Senate Bill 575. Thank you.
Excellent. Thank you very much. Always good to see you. Questions from the committee? You're off the hook. Seeing none, thank you all very much. And with that, I believe that that'll conclude the testimony Oh, I'm sorry. Yes, Senator James, yes.
Chairman Smith, I know I would like to be added as a I would like to offer a friendly amendment when we get to that point that I be added as a sponsor. I can imagine there might be some others in the committee, if that would be all right with each sponsors.
And we will do that. We
Thank you very much.
And we'll consult with the judiciary and with Senator Quarterman to the other 3 amendments at this point. I believe are friendly, but we'll get them drafted up.
Hope you think
as well.
mine's friendly.
I see Ms. O'Connor nodding her head, already emailing us in action. Further questions from the committee? All right, that'll conclude the testimony in the hearing for Senate Bill 557. So the members of the judiciary, both federal and state, and to especially in particular Judge Salas and to Ms. Wilkinson, thank you all very much for your time today and for your advocacy. We look forward to working with you all. So thank you and our condolences.
Thank you.
All right, we'll now move on to Senator Washington. I believe is here, and we'll go with Senate Bill 155. Senator Washington, welcome back. You're up.
Thank you. Seems cleared out the room. For the record, Senator Alonzo Washington here to present on Senate Bill 155, noise abatement monitoring systems. Noise from vehicles with illegally modified exhaust systems or mufflers provide problems as is a growing problem in communities across the state. Overly loud vehicles are a quality of life concern for community members, especially those adjacent to multi-lane highways where racing engines can be heard blocks away. For these reasons, I am introducing SB 155, which will enable counties and municipalities within just three counties, Montgomery County, Anne Arundel County, and Prince George's counties to use noise abatement monitoring systems to automatically detect vehicles in violation of state motor vehicle noise requirements. By using noise cameras, counties and municipalities can address excessive noise concerns without increasing traffic stops by law enforcement. I'll just note that that noise cameras work similarly to speed cameras with technology placed adjacent to the road that can measure the loudness of each vehicle that drives past it. If a vehicle exceeds 80 decibels, the noise camera is triggered to take a picture of that license plate of the offending vehicle. The cameras are also sophisticated enough to recognize the difference between different types of sound monitoring noise patterns. As such, those noise cameras can specifically look for noise caused by illegal modified exhaust pipes and mufflers. This policy is not new. This has been done in different states across the country, including in New York, where they've had the study for 2 years now. And just that pilot program for one camera, they had 500 violators. They recently added over 7 additional new cameras with anticipation for having up to 100 cameras by 2028. As you know, these mufflers that are placed on these vehicles are illegal, and it's hard for police officers to track them and to chase them down. And it happens so frequently that we just can't have our police officers sitting on every corner monitoring this. So these cameras would help make sure that we are holding these folks accountable. Our constituents are asking for this, which is why we're supporting it. I would also add that last year, the Senate delegation in Prince George's County supported it. I believe the Montgomery County delegation supported it as well, and the Anne Arundel County delegation as well. So these are only three impacted counties that in the Senate we passed. We all supported it. So with that, I ask for a favorable report on this SB 155. Thank you, Mr. Chair.
Thank you, Senator Washington. I get more complaints about this than any other issue in my district. We're going to take questions after we hear from all the proponents. So Mr. Becker, you're up. You please unmute yourself and you're good to go.
Hi, I want to thank the chair, the vice chair, members of the committee for allowing me to give a couple of minutes here in support of the legislation that Senator Washington has brought forth before you. As a homeowner who lives in downtown Rockville, Maryland, and across the street from the Rockville Metro Station, we have to deal with this problem morning, sometimes at noon, but definitely morning, evening rush hour, and then on weekends up until 11, midnight, 1 a.m., 2 a.m. sometimes. And part of the problem is it's not only the noise, but it's the speed with which these vehicles, and it's motorcycles, cars, trucks, you name it, which they have to attain in order to, well, create the loud noise. They certainly don't like driving at 25 miles an hour. So I'm here today more or less to tell you I, along with my fellow homeowners and residents, deal with this every day, in and out. And we just need somebody like a bill like this and your all help to more or less address this thing. This technology for speed cameras and noise cameras is being adopted in several locations, even in the District of Columbia. And we feel it's time for Maryland to join with this. And please help us to live an enjoyable life in our homes. And with that, I want to thank you very much. And please provide a favorable report on this and make sure it goes through the General Assembly. I thank you very much, along with my fellow homeowners and residents, and good luck.
Thank you for your testimony. Questions for the sponsor or the witness, Senator West?
Thank you, Mr. Chair. Just Senator Washington, you know we need letters this year, new letters from the three organizations.
Yeah.
So if you would provide us with those, we can move forward on this. Thank you.
Absolutely. Thank you.
Thanks.
Look forward to your support.
Wonderful. Any further questions from the committee? If not, thank you, Senator Washington. That concludes the hearing on Senate Bill 155. Thank you, Mr. Becker, as well. We'll now move over to Senator Jackson, who I believe is with us. Senator Jackson, your bill is Senate Bill 153.
Thank you, Mr. Vice Chair. Can I bring up my panel?
Please.
Good afternoon, Mr. Vice Chairman and members of the Judicial Proceedings Committee. For the record, Senator Michael Jackson, representing District 27 on behalf of Senate Bill 153. Maryland Department of Transportation, Child Exploitation and Human Trafficking Awareness Training and Response. Senate Bill 153 is a piece of legislation that's drafted to help stop the spread of the crime of human trafficking in our communities and to bring about an end to the suffering endured by its victims. It's a reintroduction from last year, and we're hoping to get this moved over to the House and through the House. This bill is a straightforward bill that does a few simple things. It will require the Maryland Department of Transportation to put into place both a human trafficking recognition education training program curriculum, offering guidance to employees and contractors of Maryland transit agencies on ways to recognize and respond to the signs associated with human trafficking, and a reporting procedure to when such crimes are recognized. As you know, Mr. Chairman and members of the committee, this is a further step in our attempt to bring about further awareness about human trafficking. The training program will require for state employees working at transit stations, airports, port facilities, and highway rest stops, as well as state employees providing transit service or employees employed under the contract to provide transit service. Elements required in the training program would include video presentations defining child exploitation and human trafficking and offering guidance as to the recognition and potential victims of such crimes. Additionally, it will require the development and implementation of human trafficking related signage and audible public service announcements throughout the Maryland transit stations, airports, port facilities, and highway rest stops. Incidentally, members of the committee, such programs and announcements are readily available through the United States Department of Homeland Security. This bill piggybacks on the co-sponsor of this legislation, Delegate Eric Ebersol. We are again in our series of bringing about and expanding our awareness pieces of legislation each year. This body passed a couple years ago the hoteliers and other lodgings setting the benchmarks for this step today. As all of you know, my professional background leads us to ensure that not only law enforcement, but all citizens have a keen awareness of signs of human trafficking. And with that, I will turn it over to my panel and ask for a favorable report on this piece of legislation. It's more than timely. We're behind times on this, and I think it's something that's very important for us to pass. Thank you, Mr. Chairman.
Thank you, Senator.
Yes.
Chairman, members of the committee, I'm Amy Blank and I'm with the Baltimore County Commission for Women. We're all painfully aware that Maryland is the hub of human trafficking in and out of the United States. So out of the 200,000 people that are trafficked every year, the majority of them are citizens of our own country. So only 14 to 17,000 people are from out of this country. So the intersection, right, of I-95, 70, BWI Airport, the port, Amtrak, all the truck stops and so forth have created Maryland's ability to enable our traffickers to find, entrap, transport, and exploit the average age of young women, 12 to 14 years old. So many of us may think that it is labor trafficking that is a part of it, particularly on the Eastern Shore, but the majority of it is sex trafficking. And so what this bill does, we're all very aware, if I say, see something, say something, we all know what we're supposed to do. This is the same thing, see something, save someone. That program has been in effect since 2002 after 9/11. And so what we're simply saying is now we would train transportation employees in those facilities, as well as Uber drivers and taxi cabs, in order to be able to identify and possibly help survivors who are looking to be rescued. So we are accepting a friendly amendment, asking for you to do the same, that would allow in the training program that those that are trained would be able to identify and help an individual to the regional navigator, which we put together 3 years ago. And I'll let my colleagues explain what that is. Thank you.
Wonderful. Thank you so much for your testimony. We'll move to Ms. Blackwell, who is virtual.
Thank you, Mr. Vice Chair. Members of the Judicial Proceedings Committee, my name is Michelle Blackwell, and I am a Senior Public Policy Manager for Uber Technologies, Inc. Thank you for giving me an opportunity to speak today on SB 153. Human trafficking is a violation of human rights that affects 50 million people around the world, with 1 in 3 victims being children. Maryland, of course, is not immune from this problem. Since 2007, the National Human Trafficking Hotline has identified 1,500 cases of human trafficking in Maryland, with nearly 3,000 victims. So obviously awareness is an important component to fighting human trafficking. Uber is already a national leader in this space. We have partnered with leading organizations to advocate for change and increase awareness about the signs of human trafficking for drivers who use our platform. Thus, Uber is supportive of this effort to increase awareness of human trafficking among drivers in Maryland, and thank Senator Jackson for his hard work and dedication on this issue. We would, however, suggest just 2 minor adjustments to the legislation to ensure that the requirement is appropriately tailored to the needs of drivers on the Uber platform. First, Uber would like to have the option to continue to offer our current human trafficking education to drivers. These materials are uniquely tailored to our industry and were developed closely with experts at Polaris, a nationally recognized human trafficking prevention organization. Allowing Uber to offer this education will help ensure that we can tailor the materials for rideshare drivers and adjust as needed. Moreover, Uber's current educational video meets many of the requirements currently outlined in SB 153. Second, we want to ensure that we are balancing the ability of drivers to get on the road with safety. As currently drafted, the bill would require that drivers complete the training before they take a first trip. We are just suggesting that drivers be allowed to obtain a provisional license prior to completing the training, while still requiring that they complete the training within 90 days of taking a trip. This will help balance safety with the needs of drivers who rely on the Uber platform to earn. Thank you for allowing me to speak today, and I can answer any questions you may have.
Thank you, Ms. Blackwell. Let's pause there because the other testimony today is for informational purposes.
If I might, Mr. Chairman, Ms. Vice Chair, we do accept those amendments as friendly amendments. And I'd like to also add that in my past life, working with the advocates for the eradication of domestic violence. Partnerships with our transportation industries were vital. And so that's why they are the next step in our awareness partnership. And we believe that, we're very happy that we're being able to garner more support in the transportation industry as they have become more, as our citizens use those industries more and more other than just bus services. And so for us, we're very happy to have them here today.
Thank you, Senator Jackson. Any questions for the sponsor or the witnesses who are favorable with amendment? All right, seeing no questions, let's move on to Ms. Emerson, who is testifying for informational purposes.
Good afternoon, Vice Chair Waldstreicher, members of the committee. It's great to be back with you. My name is Jessica Emerson, and I direct the Human Trafficking Prevention Project, which seeks to reduce the collateral consequences of criminal legal involvement for sex workers and survivors of trafficking. I'm here on behalf of the HTPP and the Maryland Human Trafficking Task Force to offer information for your consideration on Senate Bill 153. While both the HTPP and the task force support the intent of the bill, we have significant concerns about the reporting provisions that are contained within it. As written, the bill would require reporting of any suspected trafficking to law enforcement and the National Human Trafficking Hotline. As we made clear in our written testimony, the automatic involvement of law enforcement in a suspected trafficking situation can lead to further harms, including the incarceration of and/or physical harm to the suspected victim. While law enforcement is indeed a key part of the state's human trafficking response, their involvement must be solely at the express request of the survivor. We would hate for the reporting requirements of this bill to deter people who trade sex from utilizing transportation out of fear of arrest or forced engagement in services, given that the use of transportation by those working in the commercial sex trade is a key method of reducing potential harm. To sex workers and trafficking survivors, accessible transportation is safety. With regard to the requirement that a report also be made to the National Human Trafficking Hotline, anti-trafficking providers across the state have consistently reported that referrals to the National Hotline do not necessarily result in additional support being provided locally. Nearly all jurisdictions in Maryland have local resources that should be prioritized over national resources, as they are better positioned to ensure that survivors receive the assistance that they say that they need. From what I understand, the head of the task force's legislative subcommittee has been in contact with Senator Jackson, and he's amenable to, potentially amending the bill to address our concerns. We're extremely thankful for that. We just wanted to make sure that our concerns reach the committee as well. Thank you so much.
Thank you, Ms. Emerson. We have Ms. Rodriguez and Ms. Beeson who had signed up. I don't think either of us are able to join us. Yeah. Any questions for Ms. Emerson? Seeing no questions, thank you. I'm sorry, Delegate Kelly.
Okay, I'll say Delegate. Sorry, I just wanted to ask Ms. Emerson, because I heard at the end of your testimony, I want to make sure what I heard was you're working with a sponsor on an amendment. It looks like we're going to get some language that will be before us so that we can consider that. Is that right? I'm seeing the sponsor nod as well.
From what I understand, Amanda's going to be in communication with those amendments. I'm basically covering for her because she could come at the end and couldn't do the beginning, and I can do the beginning and couldn't do the end. So I wasn't involved in those discussions, but yes, that's the case.
Absolutely. Wonderful. And if I might, Mr. Chairman, as we've done in the past, we want to address the concern and not encourage folks to not come forward for fear of them being accused of something. So we've done this before. We are good with that. We'll get the proper language. So
wonderful. Thank you. Any further questions from the committee? Thank you, Senator Jackson, for bringing this important bill. Appreciate you and appreciate all the witnesses' testimony. That concludes the hearing for Senate Bill 153. Senator Carrozza is next well, you can take them in any order, but we have Senate Bill 60 here first.
Good afternoon, Mr. Vice Chair and members of the prestigious Judicial Proceedings Committee. For the record, I'm Senator Mary Beth Carrozza, and I'm proud to represent Maryland's coast. Appreciate the opportunity to present Senate Bill 60. This is a local bill. It would allow out-of-state recreational vehicle dealers to participate in vehicle shows for motor homes or recreational trailers that take place within Worcester County only. The bill would not allow deposits or points of sales from out-of-state dealers, but it does allow them to display their products at these Maryland shows. Our intent is to increase economic tourism to Maryland's coast, which is good for the entire state, and doing this through the growing consumer demand for recreational vehicles. RVs, as you know, cater to the recreational consumer with some disposable income, and they are often, as you know, very important and luxury purchases for families who are able to be at that point to make them. Similar to how boats are sold to consumers. In Maryland, out-of-state boat dealers already have the opportunity to not only display, but to take deposits and complete points of sale at boat sales within the state. These out-of-state dealers pay Maryland licenses and taxes on the registration of the boat for the Maryland resident, so taxpayers' tax dollars are not lost. This bill is fully intended to prioritize the Maryland consumer. The closest in-state dealer is 90 miles away from Ocean City, and most RV websites' max search ranges are 100 miles. The 8 other in-state dealers would not populate in the search results as they are more than 100 miles away, and therefore not available to many Eastern Shore consumers. By comparison, there are 7 RV dealerships from Delaware and Virginia's Eastern Shore, Delmarva, that are within 70 miles of Ocean City, and they also sell some brands that Maryland RV dealers do not. By allowing the out-of-state RV dealers to participate, display only in the Ocean City RV show, this would increase sales to in-state dealers. Maryland has one of the strongest consumer protection reciprocity laws in place, making it a valuable selling point to buy an RV from a Maryland dealership. In addition to these strong reciprocity laws, all RV dealerships must follow strict contracts from their manufacturers, which are from across state lines. These contracts are extremely stringent to ensure their brand reputation and consumer satisfaction under the Consumer Satisfaction Index. Should this not be met, the manufacturer would revoke their contracts with that local dealership. There was a previous issue that I want to clarify from last year's hearing on SB 642. This committee was told that Maryland law only allows RV dealers to participate in 2 annual vehicle shows per year, and allowing a 3rd RV show to take place would negatively impact the existing marketplace. However, just as exempted motorcycles from the 2 annual show cap in 2017, RVs are also already exempted under the law as seen in Transportation Article 15-304C3I. And I have submitted that statute for reference along with my testimony. Ocean City is already a tourist destination, and this legislation is fully intended to increase sale opportunities for the 9 recreational vehicle dealerships within Maryland. The success of the inaugural Ocean City RV show, which you'll hear about from Rich Hutchins, the director of that show, it was held October 12th through October 15th this past year. It attracted over 7,500 visitors from across Maryland, Delaware, Virginia, New Jersey, Pennsylvania, and Ohio. That underscores the value of this event to not only Maryland's coast, but the entire state of Maryland. By allowing more available diverse options with out-of-state dealers being able to display only their products at vehicle shows for motorhomes or recreational trailers, while at the same time continuing to allow Maryland RV dealers to display, take deposits, and complete points of sale. Again, only the Maryland RV dealers can do that piece. These RV shows in Worcester County would increase attendance and sales for Maryland RV dealers and also generate more for the Maryland's coast and the state of Maryland overall. So I truly appreciate your hearing hearing SB out. Again, it's a local Worcester County bill, and I'm asking for a favorable report on SB 60. And would it be okay if my witness is presented first? We'll first hear from Larry Nacolino, who is the director of the Ocean City Convention Center.
Mr. Chair, Mr. Vice Chair, thank you very much for affording me the opportunity to speak with you today and address the respected members regarding Senate Bill 60. The Ocean City Convention Center was opened in 1970. It was renamed to the Roland E. Powell Convention Center in 1997 after its first major renovation. It originally opened with around 50,000 square feet, hosting a handful of events, which a handful is about 10. Three renovations later, thanks to this legislature, it now boasts over 240,000 square feet, hosting over 110 events. Those events include the Maryland State Firefighters Association, the Maryland Municipal League, the Maryland Association of Counties, the Maryland Bar Association, the Maryland State Education Association, just to name a few. We also host over 20 competition-based events, such as cheerleaders, dance competitions, wrestling, volleyball, and so much more. With the addition of phase 3, including 30,000 square feet of exhibit space, again, thanks to you, an additional 12,000 square feet of pre-function, it has made the venue much more conducive to host multiple events running simultaneously. We also host consumer shows such as Bike Fest, 2 car shows, and the ever-growing Comic-Con and more. Phase 2 brought us the Performing Arts Center, again, thanks to you, bringing entertainment from around the country and guests from around the region, thousands. Which brings us to the RV show. So many of the above mentioned started small. We see this as a boon to not only Ocean City, but the surrounding area and state as well. I strongly and respectfully request that the committee provide Senate Bill 60 with a favorable report. Thank you for hearing me.
Chairman Smith and members of the Judicial Proceedings Committee. The internet has changed how people shop for RVs. My name is Richard Hutchins. I'm the promoter for the show. The internet has changed how people shop for RVs, making it possible to buy with just a click. While traditional sales are common, many buyers research and buy online or shop online before buying. It leads to quicker sales and better information from consumers. RV shows offer an ideal setting for consumers to physically explore a variety of RV options in one convenient location. However, Maryland current dealership offerings do not fully represent all manufacturers, leaving out brands such as Airstream, Scamp, Oliver, ATC, and 45 other manufacturers not represented in the state. At present, there are no RV dealerships within Worcester County. With the nearest Maryland dealership located 90 miles away, 6 of the closest 10 dealerships are within 45 miles of Ocean City, but are located outside of Maryland. The other 8 dealerships in Maryland are 110 to 140 miles away. This shows that Worcester County has a big opportunity to host RV shows that includes more options and fills a gap in the market. Amending this law would let dealers from other states just show their RVs with no sales happening at the show. All sales and paperwork would be done back at the dealership to follow the law. Just like buying a car from another state, these dealers will handle all Maryland taxes, titles, and tags fees, so Maryland does not lose out on taxes.
Our goal is to diversify the products at our show, attracting more tourists for Worcester County. This not only boosts tourism, but also sets the stage for long-term benefits like job opportunities. As we expand our product range, we foresee the establishment of more RV dealerships and repair faculties within our county, further enhancing local employment and economic growth. Thank you, and hopefully the support of SB 60.
Good afternoon, Chair, Vice Chair, Committee. My name is Ruth Toomey. I am the Executive Director of the Maryland Tourism Coalition. We are the 501c6 trade association for all sectors of the tourism industry. I am here to talk about tourism statewide. As Senator Croza had mentioned, this is local legislation to enable the motorhomes and recreational trailers for the trade show in Ocean City. The intent of this bill is to increase I cannot talk today. My apologies. Economic tourism in Ocean City. However, it does have a statewide impact. Outdoor recreation in the state of Maryland generates $8.3 billion. RV is listed in the top 5 industries, second to boating and fishing, followed by hunting, shooting and trapping, motorcycling, ATVing, and equestrian. As they mentioned, the closest dealer is 90 miles away. The show I attended personally, it brought in visitors from surrounding states, brought overnight stays, it brought in revenue to restaurants, attractions, and more. These changes are intended to capitalize Ocean City's reputation as a tourist destination in order to increase these sales opportunities for these dealerships. It is also going to increase tourism in Ocean City and in Maryland, as they are also going to visit other attractions and campgrounds in the state of Maryland. And just to wrap up, tourism is a very important part of Maryland's economy. In fact, tourism is the 10th largest private sector employer. It is creating 187,000 jobs. Tourism creates $2.3 billion in state and local taxes, saving Maryland tax holders nearly $1,000 in annual state taxes. For every dollar spent on marketing tourism by the Maryland Office of Tourism and our local destinations, $31 come back to the Maryland economy. According to RVpark.com, Maryland is home to 89 RV parks. These parks attract visitors that are both Maryland residents and out-of-state residents who are spending money and making an economic impact statewide. So while we invest in tourism, we invest in our state. We all win. Thank you very much.
Thank you. I'm just going to wrap it up and be short. My name is Paul Ellington. I represent the Worcester County Commissioners. The Worcester County Commissioners are 100% behind this bill. And just to give an analogy, many of y'all are familiar with the Annapolis Boat Show. The Annapolis Boat Show is a major boom to local tourism, and it's that way because boats can come from all over the country. Dealers can come from all over the country. And basically, this is like the car shows you go to down at the DC Convention Center. There's no deposits, there's no deals, there's no sales. It's simply a way to show your product to people that are visiting the area, that have an interest in RVs. If they want to buy something, they have to go back home to do so. So it's very simple that from our point of view, that it's just something that helps promote the tourism in Ocean City. It does not pose a threat to the Timonium RV show or any other RV shows that might exist in the state, and we'd ask support and passage of this bill. Thank you.
A question from Senator James.
Thank you, Mr. Chairman, and thank you for bringing this bill again, Senator. I remember it from last year. I remember being very interested in the subject and the dynamics. I was actually going to ask about the Annapolis Boat Show. My husband and I have been taking from our infant daughter till last year. We go to that boat show so regularly. And of course, it attracts incredible boats from all over the country, region, and internationally probably. So I was interested that the gentleman just mentioned it. So I was going to ask, how do they operate? Because they are selling theirs, right? I see a lot of vendors selling. So are you is your bill sort of similar to whatever I've been doing with the Annapolis Boat Show? Is that the idea behind it?
Well, I'll initially respond and if you'd
One of
like.
your,
So this bill, we are keeping very limited on the display only. Because we believe that that's where the support would be. And that would be, something that would open up more choice and options for Maryland consumers and anybody else that's visiting. So to me, this is about giving just more choice and options. And that's why this step, just by allowing them to display, really will open that up.
I guess my question is pretty confusing. I apologize. I actually guess I need to know how the Annapolis Boat Show works, because I said they're selling, but I don't know if they're selling boats. I mean, I bought a sweater there, right? I don't know if they're selling boats. I'm not buying a boat. I just like to look at those, So I was just trying to figure out if anybody in the panel could have just say what the Annapolis Boat Show does, not in any detail, just for this sort of issue. And then is obviously you're trying to limit it a little bit, but do they allow sales of boats outside of Maryland at the Annapolis Boat Show, since you mentioned it?
Right. Let me defer to Larry first,
Sure.
since he's going to address this particular issue.
Thanks for asking that, Senator. I can only address the boat show in Ocean City,
Oh,
which is the same
okay.
thing as Annapolis.
Does it have sailboats, last sailboats?
It does.
All right.
It does, but only on the second floor because we have, well, not only on the second floor, but predominantly on the second floor. But they're allowed.
Is that in the, this is on the dock?
Yeah,
In Ocean City?
you're talking about the Annapolis Boat Show is actually in the water.
In the water is
That's
what I
in the
meant,
water,
yeah.
but they also have some dockage and all that.
Right, okay.
The Ocean City Boat Show is a little bit different in that there's nothing water.
Even though you're
No-
surrounded by water?
We're surrounded by water. However, it's in 2 weeks. It's President's Day weekend. It's Thursday, Friday, Saturday, and Sunday, followed by President's Day that Sunday or that Monday. They sell boats from all over the place.
They do.
They're allowed to sell boats from all over the place. They can write contracts from all over the
Okay,
place.
That's good to
And what
know.
I was told by them, and I could be wrong, I was told by somebody, it's because they bring them in on trailers. And that's what I was told,
Really?
but it
That's
could
the
be wrong.
Okay,
But
I'll
that's
check
a,
that.
but that's a
interesting.
technicality.
Yeah.
Because
yeah.
I knew that I was coming in today and I'm thinking, how come we can sell boats there and we can't do
Right,
RVs?
Right.
So,
that's helpful, just because that's an odd little distinction, isn't it?
Yes.
So, all right.
above everything else.
Because you're not driving them, oh my God, they're not
Now,
driving.
now
them.
that you
Yeah.
mentioned this, Senator,
Okay,
I hate losing business to competitive jurisdictions
True.
such as Virginia, West Virginia, DC, Pennsylvania, New Jersey, and Delaware. I am the only Maryland born and bred director at that convention center since 1970.
Mm.
So I'm a little parochial.
I don't
Okay.
blame you.
And I take it personally when people leave Maryland.
Me too.
And I do not want, especially Rich and his company, to leave the state to go elsewhere, just like I don't want any other company to ever leave the state. And we've been thriving on state business.
Thank you so much. Did you want to?
Mr. Chairman, can I?
Sure,
I
yeah.
think I can help with this a little bit better
Thank
because
you.
I used to be a boat dealer for almost 20 years before going into the RV side of things.
There you go.
The difference between boats and RVs is RVs are regulated under the MBA ruling versus boats are regulated under a DNR ruling, and that's where this difference
That's a
comes
good
in.
point. That's a good point, but they are, larger than typical vehicle, ways for people, usually families, to
Right.
enjoy and vacation. So in that sense, they have a lot of overlap. So do you believe that because the boats are over here in this other category of regulation, and or because they're trailered in and not driven in, one or both of those, they're allowed to be sold from out-of-state dealers? Is the business let an out-of-state dealer sell a boat in Maryland?
Yeah, so out-of-state dealers that are boat dealers that are selling in the state of Maryland, they're allowed to because they're still paying the Maryland taxes. And that's, it would be the same thing with anything you buy, even if you're buying a car out of state, they're still paying the taxes to Maryland.
Mm.
What we're just trying to ask for is allow an increase of population to come through our shows. By allowing some of these outside dealers to come in and display only, it's going to create
I do know
more of
that-
a traffic
I
like
do
you
know
see at
that-
Annapolis.
I
and
do know
everything.
that you're only doing display now. I'm just trying to make the point I'm trying to be a little helpful by saying, let me tell you,
Mhm.
we have a big industry here of selling boats from in and outside the state,
This
right?
is a huge recreational
It's
state, yeah.
huge recreational thing, and in that sense, there's a little bit of an overlap conceptually in what's good for the goose might be good for the gander.
Exactly.
Thank you
Yes,
very
thank
much, Mr. Chairman.
Seeing no further questions, thank you all very much.
Thank
All
you.
right, we're gonna hear from, Nasir, is it Mr. Nasir, and then is Mr. Boriano here? Actually, Mr. Boriano's not here, so Mr. Nasir, and then is Mr. Landis. Come on in.
Good afternoon, Chairman Smith and the rest of the committee. My name is Philip Nusier, and I represent Beckley's RV Center in Thurmont, Frederick County, Maryland, and the Maryland RV Dealers Association. I don't have time, but I'd like to address that issue of the difference between RVs and boat dealers. I'm here today in opposition to Senate Bill 060, which would make it obviously legal for out-of-state Maryland RV dealers to display recreational vehicles in Worcester County. We feel this would set an unsettled precedent and put in jeopardy many small RV dealerships and adversely affect consumers who use our products. During my 44 years in the RV business, I've seen RV dealers go from backyard dealers to mega million dealers. Right now, there's probably 15 major dealers in the United States, and they're chomping at the bit to get into Maryland. We in Maryland have enjoyed protections from these mega million dealers over the years because our legislators have restricted the out-of-staters from participating in our local shows and exhibits. Make no mistake, just because the statute would restrict those dealers from executing a buyer's order or accepting the deposit doesn't mean that it won't happen. In order to enforce this, it's going to be necessary for us to have a whole new level of enforcement. We've seen these dealers travel hundreds of miles, bring in hundreds of units on and put them on display, and then deliver from parking lots, deliver them uninspected, and expect people to get their service by bringing them back 200 miles to their dealership. These dealers will bring in 100 units and they'll bring in 50 or 60 salespeople who will put a lot of pressure on them. I'm out of time, but I'll say, therefore, we urge you to reject this very intrusive bill. Thank you.
Thank you very much. My name is Bart Landis. I'm with Chesaco RV and I also represent Maryland Vehicles Dealers Association. We're in opposition to this bill. To do business in the state of Maryland, every RV dealer has to be licensed, bonded, and our salespeople have to be licensed to sell or show RV vehicles, any kind of vehicles in the state. Out-of-state dealers don't have that requirement. This is not reciprocated in any state that's around Maryland. We cannot go into Virginia, we cannot go into Delaware, we cannot go into Pennsylvania and show, sell, or display vehicles in those states. And therefore, I don't think out-of-state dealers should be able to do that in our jurisdiction. There's no reach for the state of Maryland for problems for the consumers. They have a problem. Who do they complain to? They don't have jurisdiction over these dealers and have, no ability to enforcement action should they have problems. So therefore, it does not benefit the consumer. And there is no way to monitor if they take money or deposits, unless somebody's out there from the state looking at all this. It's a show atmosphere. And of course, everybody's out there to sell and make money. Thank you. And we're opposition to that. I'm done. So.
Thank you.
Okay.
Thank you very much. All right, with that, that'll end the hearing for Senate Bill 60. And Senator Croza, you have one more, is that right?
Yes, I do.
All right, we have Senate Bill 68, Senator Crozo.
For the record, Senator Mary Beth Carosa, proud to represent Maryland's coast. And Mr. Chair and members, I really appreciate the opportunity to bring this bill, SB 68, back to you, which is a reckless and negligent driving, death of another, must appear violation in court. This bill, this must appear bill that we're calling Sherry and Christian's Law, we're asking for your support of this bill that would require that a person charged with reckless or negligent driving, which contributes to the death of another, must appear in court. You have heard this bill before last year with your support. It passed the committee with unanimous support and also passed the Senate with unanimous support. It was heard in the House, but did not make final passage in the closing days of session. Under current law, if someone is charged with reckless or negligent driving, even when they are involved in a fatal accident, they do not have to appear in court. They are charged with a misdemeanor and subject to a maximum fine of $1,000, and they can prepay that fine without ever appearing before a judge or facing the loved ones that are left behind. I have included a list of traffic violations that already require a must appear in court violation for your convenience. The bill is named after two different victims of two different devastating accidents. On July 5th, 2019, Sherry Sedan and her husband Thomas were out for a late afternoon drive in Conowingo, Maryland, when they were struck head on by an oncoming vehicle. Both Sherry and Thomas suffered severe injuries, and unfortunately, Sherry later died of those injuries. And I think it's important to remember the victims. Her husband, Thomas, has had to have his left arm and left leg amputated. To this day, the person who caused Sherry Sedan's death has not appeared in court to face the loved ones left behind. Travis Christian Butcher, another victim, was driving to work the day before Thanksgiving in 2016 when he was hit on Route 7 in Abingdon, Maryland. He had the right of way, but the driver did not yield to him. After 3 days in shock trauma, Christian passed away from his wounds. He was only 19 years old, and despite a long rap sheet, the driver never had to appear before a judge for her actions. Again, we're remembering the victims. I would like to publicly recognize and thank the members of Abate Maryland who are here today in support of the bill for all the work that they have done on behalf of the families of the victims of negligent driving. They have worked hard with these victims' families. They have been advocating for this change, for this must appear in court. And we are encouraged that it passed the Senate. And we are asking again for that support. I think it's important to note that there is a revision to the bill that we think will help with passage on the House side, and that's for a good cause. The judge may waive the requirement to appear in court. This is to allow the court, for good cause, some discretion should the two parties meeting not be in the best interest of the victim's family. These type of cases where there is a victim should not be treated the same as a victimless vehicle accident. Mr. Chair and Vice Chair and members, I have appreciated your past support for this needed change and ask you for swift approval of SB 68. Thank you very much.
Thank you very much, Senator. Questions from the committee? Seeing none, that'll conclude the hearing for Senate Bill 68. Thank you very much.
Thank you, Mr. Chair.
Thanks. All right, we'll now hear from Senator Kagan with Senate Bill 10. Senator Kagan, welcome.
Thank you, Mr. Chairman. Perfect. Thank you, Sandy. Very fun. Speak first. Yeah, absolutely. we go. Then I'll just be the down here. You can just leave it. I can stop it from my side. Look at that. Okay. Good afternoon, colleagues. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. Senate Bill 10, and out of respect for the load of the Judicial Proceedings Committee, as I told the chair this morning, I brought one witness, but I did bring him down from New York City. And so I'm really honored and grateful that he's with us today. But I'm going to start by giving some testimony. Then I have a brief PowerPoint just to amplify, and then I will head it off to the witness. So this bill is about both public safety and, frankly, revenues. In my very first year in the House of Delegates, I outlawed tinted license plate covers because there are issues of public safety and identification. That law still is in effect, but more and more what we're seeing is license plates that have either been manually defaced, on purpose covered up with spray paint or other things, or have just degraded over time. And that has an implication for public safety. There is a shocking number, according to the Maryland Department of Transportation, 380,491 reports were made to the Department of Transportation of obstructed or defaced license plates. In the city of Gaithersburg in 2022, of the 8,878 violations that were identified from just one camera in the city of Gaithersburg, only 5,426 of those could get citations, and that is only 39%. So what are we talking about here? And what are the public safety implications? Bottom line is, if the cameras can't read your license plates, or frankly, if law enforcement can't read your license plate, that means you go through a red light camera, you're off scot-free. A speeding camera, no one is going to send you a citation. A hit and run accident, a pump and run at a gas station, finding suspects for outstanding warrants, locating people who are missing through Amber Alerts or Silver Alerts, a senior citizen or someone who's been abducted, or recovering stolen cars. Defaced license plates cost us a lot of money. And I just want to say that it's been estimated that in 2018, speeding cameras, and just speeding cameras, not red light cameras, not easy pass tolls, but $64 million was collected in 2018, and about $100 million annually for speed cameras, red light, and toll cameras. So at a time when we are having budget challenges, this is real money that we are not collecting. We're going to hear from Gersh Kunzman about New York State's numbers, where he's an expert and has a blog. So I'm not going to spend time on that, but we're talking about millions of dollars potentially that needs to be captured. So Senate Bill 10 proposes really modest, a really modest solution. First off, on the first offense, you're pulled over, you would be able to get a warning. We propose building in a 60-day grace period for you to get a new license plate from the MVA and affix it to your car. On a second offense, you would get 3 points added to your license. Now, we didn't do any fees or anything in Maryland. I know that everyone has different views on fees, but I will say that in Pennsylvania, there are 24 other states that already outlaw this. In Pennsylvania, there's a fine of $100. In California, the fine is $250. So I leave it to the committee to think about whether fines are appropriate. Literally, these people have gotten away without paying their fines. So I want to give a shout out to the MVA and specifically to Administrator Nizer and her team. They have been super collaborative in all this with sharing data. They even started a pilot program because sometimes it's not that the driver's a bad person or trying to cover something up. They just have a license plate they've had for 15 years or more, and it has just degraded. And so there is a free license plate replacement program that they have started. So when you get your registration renewal, there's a box that just says, yes, I need a new license plate. And so we can get those sent out at a really modest cost. So let's run through the PowerPoint just to give you a sense of what we're talking about. And I'm going to go through this somewhat quickly if we can start. Is it me or you? Yes. Okay. So again, I've already covered this. The license plate threatened public safety in all these ways, speed cameras, red light cameras, and missing persons and stuff. It costs us a lot of money. Again, $100 million, and that was 5 years ago, and that's just an estimate. We're going to hear more about New York City, where the data is available from Mr. Kunstman. Here's some of the examples, and these are just photos that I've taken in recent months. And seriously, this is increasingly common. So this has reflective spray paint on it, which means that the camera cannot identify this car. Even worse, and here the original paint seems to have has peeled off, and unclear whether this was covered up, spray painted, but obviously a camera would not be able to identify this license plate. Here, another example. This person clearly was in an accident, presumably, but hadn't seen fit to contact the MVA to get a new plate or to reaffix it so that the license plate could be photographed if there were a violation. This literally was last weekend. The front license plate was perfect. And I talked to the gentleman who was the driver, and I actually asked him, I identified myself, told him about the legislation. He said that he had had his car outside for about 6 months in the sun, and that he took it to a car wash, and that the brushes or something had removed it. And Administrator Nizer was surprised by the strength of those brushes, but I took it at face value. He seemed like a totally cool guy. But this person, if he did go through a red light camera or a speed camera, clearly he would not be getting a citation. So again, the proposed penalties that we are suggesting, but whatever this committee thinks it makes sense, but we think a warning is appropriate if they hadn't noticed or they had never known how easy it was to get a replacement. We just give them a warning, give them 60 days. That would be an amendment for the committee's consideration. We think that that's long enough but short enough to let them get it replaced. But after that, there really should be a more serious penalty. So 3 points is what's in the bill. And again, the MVA is continuing its program that they've just launched recently about offering drivers the opportunity to get a new license plate for a plate that's 15 years or older. And to be clear, and that is only for our regular plates. So if it's a bay plate or a custom plate, that would have a fine, and that would not be as automatic. So with that, I am happy to take questions, or Mr. Chair, if Gersh, Kunstman, whatever your preference. Thank you. Okay. So Gersh Kunstman, again, came down from New York City, his blog and his work. And I should let you know that I first heard him on NPR, and his work is nationally known and legendary on specifically this issue. Thank you so much for being here.
Oh, I didn't know I had a publicist. Hello, Senators. I am Gersh Kunstman, a longtime New York journalist and currently the editor of the transportation news site Streets blog. Over the last 3 years, I've intensely covered the growing problem of drivers who deface or cover their license plates to avoid being held accountable for their recklessness. Now, first, how reckless are drivers in New York City? Well, in New York City, we have 2,000 speed cameras covering pretty much the whole city. And those tickets issued 5.9 million tickets last year. That's roughly 16,250 per day. And those tickets only go to people who are driving 11 or more miles an hour above the speed limit. We also have a red light camera program, very small one. It only is about 1% of the intersections. Those cameras wrote 704,000 tickets last year, and that's about 2,000 a day. But we have a snake in this enforcement Eden in New York, drivers who seek to evade accountability. Initially, when all these programs started, unreadable plates comprised just about 1% of cars that triggered the speed cameras. As I said, when they go 11 or more miles an hour over the speed limit. But by August 2022, that number had jumped to more than 7%, as Streets Blog reported. And the city comptroller recently found that last year, 1 million speeding incidents, these are people who were caught on camera, could not have the image transferred to the Department of Transportation because the image couldn't be read, the plate couldn't be read because it was either covered or defaced. Now in New York, that number is likely to rise because we have congestion pricing, which is a new tolling system coming in. But also drivers are finding more ways to trick the cameras. For example, online retailers like Amazon and eBay are filled with offers for customizable plates. For just $20, you can get anything you want on it, even a license plate number, just your own license plate number. And souvenir shops all over Manhattan are selling cheap metal plates for $9. Now, I brought one with me. I thought you'd get a kick out of this. It's obviously a fake, appearances to the contrary notwithstanding. But this plate actually was caught on camera 3 times last year in New York. Where did the tickets get mailed? No one knows because it's not registered to anything. And Mr. Chair, you'll probably have to fight it out with the senator for this one. In New York, no points, no points are assessed against the driver's license when a driver is caught with fake or covered plates. Currently, the maximum fine is $200. In New York City, it's even lower. And most drivers just consider that the cost of doing business because they're very rarely caught for that. Even camera-issued tickets for reckless speeding do not carry points in New York, though tens of thousands of drivers have accumulated enough tickets to have their licenses revoked if those tickets had been written by an officer, but again, they can't be everywhere. So drivers simply evade accountability by paying the $50 fine. Okay. Efforts to tighten the rules have failed. In 2022, we had some efforts to make points part of the license. That didn't fail. That didn't succeed.
Their time's expired. I gave you some extra time because of the sexy license plate thing and your comments. And you came down from New York, so we gave you some extra time. But no, I think your time's expired. So I just want to be respectful of other witnesses. But we have a number of questions, so I think this dialogue is going to continue. I saw Senator Folden first, then I saw Senator McKay, then Senator West. So we'll start with Senator Folden.
Can do Mike first. It's fine. I'm a sheriff. Thank you, Mr. Chairman. I appreciate you bringing the bill forward. I just have a few questions for you on it. Because as you're well aware of, I believe that there's already a law in place for materially altering a motor vehicle registration plates. It's $280. And then, so you brought up like the anti-reflective spray. I'm not sure what how you intend to overcome something like that, because you're not going to be able to tell and you're not going to be able to read the tag regardless. So I don't understand. I have concerns from a law enforcement perspective that in a time that we have continually made demonized and attacking law enforcement, that we now want to put them in a position to conduct traffic stops with no fine associated with it and only the ability to give a warning. I think that's absolutely reckless, that you're endangering officers' lives. You're minimizing an officer's life because the two most dangerous calls that a police officer responds to is domestics and traffic stops. More police officers are killed on those two things. So I think this is reckless that you would think that it's okay for an offense that has nothing other than a required warning only, that they're going to put themselves in harm's way for that.
So Senator Folden, first I'm going to take exception to the idea of your accusing me of disrespecting law enforcement officers. I work very closely with them, and I think you're saying that I minimize them or want to put them at risk. It's just not fair. So
I didn't accuse you though. I want to be clear on the record. There was no accusation made.
So the photos that I took were taken in parking lots. So it doesn't have to be necessarily that a police officer would have to pull someone over. It would be an option. But certainly as there are people on the beat in the neighborhoods, they can certainly notice a defaced license plate or a worn out license plate. So that's number one. The reasons for them being illegible by the cameras or by a law enforcement officer can be broad and varied. And as you said, obscuring a license plate is already against the law, but one degrading And the law just isn't clear enough that this just isn't covered. And that's why the new pilot program, and that's why this is so important. When I talked about the Gaithersburg number of violations and 8,878 violations from one camera in Gaithersburg in 1 year, and only 5,426 became citations. So some of those were defaced or obscured or degraded license plate. Some were the flash bulb didn't work, or it was an emergency vehicle, an ambulance going through a speed camera, and that's what we want and need them to do. So I just wanted to clarify that. Gersh, why don't you add on for Senator Folden?
Well, just to respond to one thing while he's getting up, I mean, it sounds like your constituents in Montgomery County might have an issue with your money grab legislation on speed and cameras like that.
Hey.
I know it's your county too, but it is. There's more. How many more in Montgomery County? How many more cameras does Montgomery County have than anybody else per capita in the state? I think that's an interesting question, because this is about money being lost more than it's about
just say you're right on the substance, but just in the framing, let's be more civil on that. It's because it wasn't her money grabbing legislation.
How much money does Montgomery County get annually from their camera citations between red light and speeding cameras annually?
As you know, Senator Folden, it's a statewide program, red light cameras, speed cameras, Easy Pass. If you're going to the beach and you're going over the Bay Bridge and you don't have an Easy Pass, you get a toll that's sent to you. If you drive on the ICC, the Inter-County Connector, and you don't have an Easy Pass, you get a citation that is sent to you. So in terms of the number of cameras in Montgomery County, I don't possibly have that data. I'm a state senator and this is statewide legislation. To be clear, money grabbing, again, forgive me, that is offensive. I started this with public safety. I talked about the need to be able to identify people who are wanted under a warrant. I talked about saving kidnap victims and people who may have dementia, a silver alert or an amber alert. So this is public safety, and these are scofflaws who are getting away with not paying the fines for laws they have broken because we can't identify them. So Gersh, I don't know if you would.
Senator, I appreciate the question. I think the only thing I would add is in our experience in New York City covering these, we have enormous numbers of what we call ghost cars that can't be tracked by law enforcement and actually present a threat to not only law enforcement, but to your neighbors and your children. Because in New York, you only get a speeding ticket if you're going more than 11 miles an hour in a school zone. So that's pretty fast. And if you can't read the car, you are endangering the very people you're talking about.
Okay, I'm not sure that, I understand, I appreciate the comment, but neither of you answered my question, which was how much money does Montgomery County make? Because they're the ones. I didn't ask the number of cameras. I didn't ask any of that. That's what you answered, Senator. I asked how much money does Montgomery County make annually off these? And it's a known value because you guys have it. You guys have a very significant revenue source from these cameras.
Senator, I can get that for you. I will make that request for you from our county government.
Okay.
The MVA is in the room. I don't know whether they would have easy access to that information, but I would doubt it.
I can get that for you.
Okay. So thank you.
All right. So I think Senator McKay, then Senator West.
Thank you, Mr. Chair. Thank you, Senator. So my question has to do with vanity plates. I know that there's a replacement program, checking the box and that kind of stuff. And you said nominal fee. Some of the vanity plates, such as fire EMS, they don't pay for their plates. So is that factored into that? Is there an actual still fee for them? So I don't know the answer. Maybe the department knows that answer.
Yeah. So
in her testimony, it can.
You want to come up? So the MVA is here to answer technical questions like that. So thank you, Senator McKay. And Administrator Nizer is across the street or in another committee. So.
For the record, April King with the NBA. How are you?
Excellent.
So right now, our pilot program that just started, we are doing standardized plates only.
Okay. All right. Thank you.
You're welcome.
So if there was a degraded custom plate, how would that be handled?
So they would still have to pay for the replacement of that plate.
We may, maybe you might be entertaining an amendment that may address something like that.
Great.
So I can get with you, the senator, to work on that. The other second question, thank you.
You're welcome.
The second question I have for you, Senator, 3 points. I mean, that's a lot. And I look at, a lot of times I believe these plates are not necessarily nefarious in mind. It's people that, okay, I'll get it changed one day. Oh, actually I lived another day, so I didn't have to go get another plate. But 3 points is a lot to be added. And I was just trying to understand what the reasoning was around the 3 points. Because I just look at communities that have pockets of poverty.
Sure.
And 3 points is a lot.
Sure. So
When it comes to renewal of insurance.
great question. I have been working on this issue with our bill drafters, with the Motor Vehicles Administration, and this committee, frankly, sometimes doesn't like fees and fines and penalties. And this seemed like we mean it. We really need your plate to be legible, and we hope you don't ever have a violation that would cause you to get a fine, but you don't get to skip out on it if you do. And again, the 60-day grace period is what we are suggesting. But this bill is in the domain of the committee. And so if you think of $100 fine or $250 fine like Pennsylvania or California, if you think that makes more sense, that's good to me. We were trying to avoid that, but we just think that people should be getting their new plates.
Understood. Thank you.
Thank you.
Thank you, Mr. Chair. I had never had any idea that this bill was needed because we're losing so much money. So let me just say that I've been around a long time, and I can remember the era when every 3 or 4 years I would get a new license plate and have to fix it to the car. The idea that we only get the plates replaced when we ask to have them replaced, and you get a free one after 15 years, but it almost sounds like the DMV is causing this problem by not replacing our plates more frequently.
I'm going to toss that to April again from the MVA.
Hi. So right now we saw a need that there was an issue with obscured plates. So that's why we started this pilot program to see, we have to collect this data since it just started. How many years does it look where we need to replace it? I wish I could provide more data for you to say at 15 years, this percent, we can keep going up in years, right? We can go to 18 years, or we can cut back.
Isn't there some sort of a national standard on how many years we're going to have to do this pilot before we'll figure it out? It would seem to me the more years that go by, the more likely it is the plate's going to be old, dented, tattered, torn, obscured because it's dirty. And wouldn't it be better for the MVA to be proactive as it used to be and automatically replace the plates every couple of years?
Just one other thing is that when you buy a new vehicle, and a lot of us buy vehicles more often than once every 15 years, and you can get a new plate with a new vehicle, as many people do. And so that also addresses this issue.
Yes. So right now we want to just make sure that we're collecting our data, correct? Since it just started, we just want to see, I can definitely get you the percentages of how many people are requesting replacement plates due to obscured issues on their cars. I have no problem doing that. We can pull the data from our agency.
One last question, and that is, if I were, for example, driving along the Intercounty Connector and went under those devices to track the fact that I'm driving along, and I do have an Easy Pass, but if somebody didn't have an Easy Pass, why don't you station police along the way to flag the fact that this car that just went under the machine does not have an Easy Pass, or it didn't register, and the police can see whether the plate is obscured or not, or maybe the machinery could tell you that plate was obscured, and then you stop them on the highway and give them a ticket.
I might suggest that that's not how our state police might think is the best use of their limited staff personnel.
Okay.
for maintaining public safety. I understand in the best of all possible worlds, but I'm not sure whether they would do that.
Senator, I just want to add one thing. You mentioned the idea that the license plates degrade over time.
Yeah.
I would tell you that our
They get
experience.
dirty.
Yeah, I would tell you our experience in New York is that people are egregious when it comes to willfully abusing their plates. For example, if you have an E on your plate, it's very easy to turn that into an F. And we see it over and over. I've documented hundreds of these cases just in the last couple of months.
Well, I hope that Marylanders are more honest than the people.
We've always said that.
I've never noticed somebody doing that or, seen a license plate which was obviously defaced. But if that kind of thing is happening, there ought to be criminal laws which would apply. Thank you.
That's what this would offer.
Thank you, Mr. Chairman. Thank you, Senator Kagan, for bringing the bill and making an interesting hearing. My questions are really to the Maryland Department of Transportation.
MPA, yeah. April.
I wanted to make sure I understood a few things. You currently have a pilot program.
Correct.
Right. And when did you start that program?
Late December, early January.
So very early.
Yes.
And what did you think the duration of the pilot program? What would you like that? What's its designed? How long is it going to go?
That is something I would have to get for you.
So I would like to know that, what you were hoping to learn, whether you were going to issue a report, because it seems to me you're already in sort of the infancy of deciding whether this bill would be a good idea. So rather than jump to do the bill, I'd like to see you finish your pilot program, report back to us, because it may be that you would do this bill. It may be that you would do something a little different, or we do several things. So I mean, just to sort of allow for a pilot to do what it's supposed to do.
I would be very happy to
I'd love
get some information for you about, how long we would like to do that, what this looks like, and send it to your.
Yeah, cool. So then I also would like to know, because
Sorry,
I'm looking at
Senator James,
your
can I
letter.
just add to that one second
Oh.
on this? Because this pilot program was started because of this bill. And frankly, it wasn't originally the intent to include the mandate for the program in the bill. Whether or not the pilot program continues for 6 more months or 6 more years, the reality is there needs to be a consequence. And so this bill is about making sure that we get the.
Yeah, I appreciate that. I have more questions and that would have gotten to that. So I get that, but that's a penalty and I will get to that in a moment. I'm just focusing on the fact that we have a pilot program that is less than 60 days old. And I'd like to see the pilot program to its conclusion and its data before that part of the bill is addressed. So then let me just go to this other part. This is your letter, or it's MDOT's
Yes.
letter. So, and you can get back to us, either one of you. I appreciate that you did give us a reference point for about 388,295 and some other similar number on the number of obstructed plates that were reported in 2022 and 2023 respectively. A couple of things I need to know to put those numbers in context. I need to know the total out of which this number is derived, right? I guess this is what total people that go through Easy Pass tolling.
So just to clarify, so we went into a joint letter. Our portion of the letter, the MBA's portion of the letter, is that second half. The numbers you were reading from are from MDTA's data. So I would be happy to reach
So
out to
just get
my
perfect.
colleagues.
That's fine. You don't have to. I'm just asking you to get back to me. Don't you dare worry about whether you can answer them right now. And I guess what I'm trying to figure out, and the other thing I'd like to know is how many of these are in state or out of state. Now, maybe it's all in state, but just to clarify that, because I'm not sure there's an in-state, out of state,
I'll make sure they get back to
demarcation.
you.
Yeah. And then I guess the last couple of sentences, again, not for you to answer, but to get back to, I'm reading this. This sort of, I think this is the last sentence of the first full paragraph of MDOT. Given that all law enforcement agencies in the state do not utilize the same citation reporting program, the current law would be preferred to allow law enforcement to make determinations on a case-by-case basis. I think I'd like that clarified. I think what they are saying is the bill is mandating, it has a challenge, I think, that first offenses get a warning. And that second offenses, I guess everyone's saying that the second offense is 3 points. I'm not sure. Could you just get MDOT to clarify what that last sentence meant and whether or not what I think it means is they like the current law, which gives law enforcement officers discretion, but I may be misreading that sentence. So I just want to understand sort of what that last sentence means there.
I will make sure they clarify.
Awesome. Thank you so
Thank
much.
you.
Thank you so much, Mr. Chairman. I think I'm the last question. Thank goodness. I had a clarifying question for the MVA, but did want to thank you, Senator Kagan, for bringing the bill in. And I understand your intent was excellent. And I apologize that you were treated with hostility. You deserve better than that. My question is actually process, and I think you can just inform me as to why this can't work. But I am a person who doesn't do things, right? I'm very lazy. I lose mail. I own this about myself. As I look at the process that's set up, if something were wrong with my license plate, maybe I'm not aware, maybe I am, I haven't addressed it. I get the notification, I need to replace my plates. I don't do it because I'm irresponsible. And then I get 3 points eventually. Is there a way that the MVA could intercede and just replace my plates for me and take my other plates out of service? Or are there security reasons why we can't do that?
Well, as the pilot program works now, what would happen is when you get your notice that it's time to renew, or when you go to renew, you would check that box. Once you check that box, the replacement would happen. So you wouldn't be coming in to make sure.
So I'm just asking that if I get a notice that says my plates are obscured, here's your new plates. Can the plates come with, and why can't they come with that notice?
So just to clarify, I'm sorry, I just want to make sure I'm understanding your question. So you're saying you're pulled over, you receive a warning.
Right.
That you would like the MVA to be notified of that warning to send the plates.
Yeah, that's my question. My question is
Okay.
why can't it work that way?
That is a question I would have to take back to my team of would that even work with the process and how that would work?
I think that just to Senator McKay's concerns about putting points on people's license, I would prefer us to be more proactive in the solution in terms of getting people plates that work. But I understand there may be reasons that I'm not thinking of as to why that couldn't work. So thank you.
Okay, so I'm just gonna go ahead and go on the record here and address anybody's feelings that thought I was hostile. I don't think it's appropriate for another member of the committee to impugn my actions or my intent. So I'll leave it at that. Have a wonderful day. Thank you for the bill.
All right. So as we move forward, I appreciate the dialogue. We'll keep it constructive. Too early in session for this to degrade. I know both members here. I know them both. And you're both public servants and both here to do a good job. And Senator, thank you for bringing the bill. We'll proceed on. Make sure that we treat each other with civility, and we'll have those discussions as we continue. So I appreciate it. Thank you very much, Senator.
Thank you, Mr. Chairman.
Thank you for
Before I
coming down
leave-
from New York,
Yes.
and thank you for being the star of the show here. For the
Yeah. And I just want to thank my intern, Yanu Rowe, who did some really yeoman's work on this. An intern who's just super smart and hardworking.
Excellent. Well, thank you very much.
Thank you all. Take care.
All right. All right. With that, I think it's Senator Bailey here. There he is, Senator Bailey. Senator Bailey, you're up with Senate Bill 63.
Good afternoon, Mr. Chairman and members of the committee. Senator Jack Bailey, St. Mary's and Calvert County, District 29. Today, I'd like to talk to you about Senate Bill 63, which would change the current state requirement for school bus drivers to pass medical examinations from annually up to 2 years, with individual school systems retaining the ability to require these examinations more frequently. Understanding the new rules of this committee, I just want to remind everyone that Senate Bill 63 is identical to House Bill 71, which passed this committee last year. It was on the last day, but it passed unanimously. This legislation would make Maryland's state requirement consistent with current federal requirements, as well as those in neighboring states, including Pennsylvania, Delaware, and Virginia. I respectfully request a favorable report on Senate Bill 63. Thank you for your consideration. I would stand for any questions. I did have two people that did sign up for this, and I hope everybody just understands that CDLs, it's a 2-year issue. In Maryland, if you're a school bus driver, you've got to do it every year, and it's a big expense, and we're just trying to take it back to 2 years, what everybody else has.
Would you like for your panel to come up? I have two folks.
Yes.
Mr. Thompson and Mr. Hughes.
Yes.
Welcome.
All right, good morning, Chairperson Smith and members of the committee. So my name's Jeff Thompson, and I'm the Director of Transportation for St. Mary's County Public Schools, and I've been the director for 17 years. So I'm very familiar with how things have changed over time with FMCSA and CDL license holders. So that's the big key here, is things have changed. You know, there was a time back 30 years ago, 20 years ago, when there was no oversight by the state, by the federal side of things. And so now things have drastically changed in the last 10 years. You know, 10 years ago, about 10 years ago this month, FMCSA started requiring states, the MVA, to collect or CDL physicals from CDL holders. That used to never happen before. Then they required that all the persons, the medical examiner signing off, had to be on the national registry, had to pass a test, have to have an examination. They had to be certain people were the only ones allowed to sign off on it. In addition, we have the clearinghouse now, the Drug and Alcohol Clearinghouse that FMCSA requires. And that soon will be linked with MVA, or as a downgrade license for CDL holders if they fail a drug test. FMCSA also has the entry-level driver training requirements now, that everyone now has to go online to set up their training, to register their training and what different items they've accomplished. And pretty soon the medical examiners for the CDL physical part will directly import it into the federal system. So with all these changes, I fully believe with this bill, if it passes, there'll be no impact on student safety. It's important to keep in mind that if there are concerns, the directors of transportation or even the general public can go to the Maryland Medical Advisory Board. For many school bus drivers and school bus operators and school systems, this will be a welcome relief during these difficult times, and it will eliminate unnecessary trips and payments every other year. This change will have school bus drivers on an equal time frame with all other CDL drivers in Maryland. I thank you for your time, and I appreciate your support for Senate Bill 63. Thank you.
Good afternoon, Mr. Chairman and other members of the committee. My name is Desmond Hughes. I'm the Director of Transportation for Wycomico County Public Schools. In an effort not to be redundant from my colleague and Senator Bailey, again, it's just to, this legislation is just to, again, to align Maryland with the federal regulations that many of our neighboring states currently have. I think there's only about, my last check, there was only 4 other states, including Maryland, that had a specialized law for school bus drivers other than any other commercial operator. And then lastly, I would just add that this provides us some flexibility in the student transportation industry. As probably many of you know, there's a school bus driver shortage that we've been facing for a number of years. We rely heavily, or I should say, we rely, some of us more heavily than others, on part-time drivers. Some of these drivers, CDL operators, do other things like truck driving, dump truck driving, farmers. This annual physical kind of presents challenges for them because they have to go every year versus every 2 years. This every 2 years or biannual physical will certainly give us another tool in our toolbox to be able to recruit and retain some of our school bus drivers that we are certainly experiencing a desert for. So again, I would ask a favorable report from the committee. It was before you guys last year, and it came out with no opposition and unanimous on both chambers. I believe the clock just ran out on us for the piece of legislation. But I appreciate your support and thank you for your time.
Thank you very much. Questions from the committee? Senator James.
If you don't know the answer, you can get back to me. I just am curious about the history of why the law is as it is currently with the annual. So no data or even firsthand knowledge. My first thought was maybe we did it because at the time people thought this would absolutely ensure or increase the likelihood of healthy drivers and so it has a public safety component. So I would just, to help me decide, and I think I probably supported the bill last year, but I didn't think to ask this question. I just want to know why that had happened. And if you don't know, that's fine. Or if you could point me somewhere, because as the chairman knows, I do my homework, whatever that my coffee cup says, but some research. I just would like to look into like why it was the way it is so that it'll help me better decide how to deal with the bill.
Well, I think you had a time when there was no physicals required, period. And then when you moved into more of the CDL and more of the licensing requirement, that's when they started requiring school bus drivers to have a physical. And it was basically done every year. And wasn't passed by this body. It was a regulation that's under MVA or under DOT. So it wasn't a passed item through.
I just want to know why it was put into effect and what the history is. And if you're saying to me, look, it's not the legislature, it was a reg, then I'll go to the department and I'll ask them to, if they can, pull up the history on that reg, which may or may not exist.
Yeah, I think it was a arbitrary number set in time 30 years ago. To think that basically every summer, the school bus drivers would get a new physical prior to the school year, and it would cover the school year to make sure it was covered and that they had it on record. And the only people that actually kept copies were school systems. And it was supposed to be the employers if they were separate. So there was no copies that were kept by the DOT, MVA at that time. It was just the school systems, which is in the regulation. And so every year we did that. And what we're finding now, one of the issues we're finding now with the new FMCSA requirements with MVA is that because the drivers have to go every time a new DOT physical is required, it keeps backing up because they have to keep getting it earlier and earlier. So instead of before, it used to be every summer, all the school bus drivers would get CDL physicals. Now it's spread out throughout the year, and it's made it complicated for a lot of them and tracking purposes and money purposes and different other.
If I could argue against you could tell us thinking about whether we were undercutting a prior wisdom about public safety and health. I would argue the other side would be, look, we are better at everything in terms of diagnostics, prevention. And so with all of what we have today, blood work, I assume is involved and all that, probably what they could do 30 years in an annual physical, we probably are just as good at getting to someone's underlying health every other year just because of the incredible advances in medicine. So that might be
with the new the doctors now are much more stringent than what they ever were before, because before people would go to their family doctor who didn't have any background or training in the CDL testing.
That's a good point.
And DOT testing. So now the doctors have to be on the registry. They have to go through a test. They have to pass the test. And then when they're given these things, they're looking for certain items. So we see a lot more limited timeframe physicals, a month, 3 months, 6 month physicals compared to before. It was just almost a flat out. They would just give
That's a great talking point. Lead with it, because then you don't have to worry. It's probably medically unnecessary. Thank you. Thank you, Mr. Chairman.
All right, thank you very much, and that ends this hearing. Senate Bill 316, Senator Bailey.
Thank you, Mr. Chairman. I'll bring my panel up if that's okay. Good afternoon again to the chairman and members of the committee. Senator Bailey from St. Mary's in Calvert County, District 29. This afternoon, I want to talk to you about Senate Bill 316 that would allow counties and municipalities to permit the use of golf carts on county and municipal roads under certain circumstances. Each session, Remember, I sat in these chairs here in JPR. We had multiple bills brought forward by individual communities and counties requesting authorization to allow for the use of golf carts in their neighborhoods. There are several locations in our state that have received this authorization, including one of my communities, Golden Beach, which is in my northern end of St. Mary's County. For the last several years, the commissioners, both in my counties and others, have requested authorization to allow them to designate other communities where golf carts could be used. I believe that we should permit all Maryland counties and municipalities to have this authority without coming back to the General Assembly for each and every county and each and every road. We should not be considering this individual legislation relating to this wage time we want to say where a golf cart's permitted. This bill does not require a county or a municipality to permit a golf cart. It only gives them the authority to do so. Local governments are the best authority to determine what is feasible and safe on their local roads. It also includes several limitations on this authority to ensure that the public safety is protected. As amended, golf carts can only be used on roads with a speed limit of 35 miles per hour or less between dawn and dusk, and with lighting devices as required by the MVA. The driver is also obligated to keep the golf cart as far to the right of the roadway as feasible. These limitations are modeled after those that are in place for communities where golf cart use is currently authorized. It is also important to note that this bill does not permit the use of golf carts on any state highways. I am introducing with this bill an amendment that increases the maximum allowed speed of golf carts from 30 to 35 miles an hour. And that's the way it is currently in St. Mary's County in Golden Beach. And that's the way it's been for several years there. I respectfully request a favorable report with this amendment, and I turn it over to my esteemed colleague, Mr. Bariano. Thank you.
Thank you, Senator. For the record, Bruce Bariano, I'm a lobbyist for St. Mary's County, very proud of it. Mr. Chairman, Chairman Muse, and members of the committee. I really can't, no need to repeat what Senator Bailey indicated. This bill is not mandatory. It's an issue that has already been addressed by the legislature on a piecemeal basis. Does not need to be continued that way. In addition, representing St. Mary's County, I also have the privilege and the honor of representing Caroline, Queen Anne's, and Washington County, and they're very interested in this as well. Not just St. Mary's County, although I'm here in that capacity. It's dealt with more comprehensively and in a better sense to have it done at the local level in a comprehensive way with the restrictions of this bill. Would really urge a favorable consideration. It just makes a lot of sense, and the basic premise of allowing the use of a golf cart as a vehicle on roads has long been addressed by the legislature, that yes, that can be done. As the senator indicated, that is the case in various counties and areas in the state. It'd be less pollution by using a golf cart than using a vehicle. That could be another thing to consider. So that might be a good thing. I would urge a favorable report and hope you would pass this legislation. Happy to answer any questions.
I love you because it's been a long time. I guess 100 years since I've driven a golf cart. Way back in my younger days, I used to do that. You said that the maximum speed in this bill is 35 miles an hour, or something like. How fast can a golf cart go? I mean, what is it?
The 35 miles an hour does. The 35 miles an hour does not refer to the speed of the golf cart.
Got you. Okay.
It refers to the maximum.
I was getting ready to say, I wouldn't have given it
on
up
the
right.
roadway, right? And the golf carts that I'm familiar with usually go about, I don't know, 10 to 15 at a maximum.
That's what I thought. Okay, if they changed that much, I was going to trade my car in. But okay.
Yeah.
Any other questions?
Senator, I've never driven a golf cart on, right, it's not the Mercedes Benz, so.
Thank you both.
We all
Any
understand
questions?
that. No, but it's, yeah,
Thank you. Thank you. Any other questions? Okay, thank you.
thank you.
Thank you.
Okay, that concludes this testimony, this bill. What is it?
Senate Bill 357.
Senate Bill 357. Senator McCray.
Thank you, Mr. Chair. And is it okay to bring up the panel?
Absolutely.
Mr. Chair, Mr. Vice Chair, members of the committee, for the record, Corey McCray, Senator for the 45th Legislative District. Today, I'm in front of you in reference to Senate Bill 357. Senate Bill 357 is a local bill. Eventually we will have a hearing within our respective local delegation to make sure that we can get a letter to the respective committee to move forward. Mr. Chair, I'm not sure if you know, but like this ghost tags has been a big thing. These tags where you have Virginia, other out-of-state tags riding around in our respective state where they're not bringing in the revenue that will be brought in from a transportation standpoint, but also like just the insurance mechanism, like not making sure that folks are protected by simple having car insurance from that piece. We've watched this amplify very much up. On a number of our polls, you'll see signs that say, get tags from Virginia and things of that nature. So it's becoming a very prevalent business from that standpoint. And my city is just trying to get in front of it. What they want to do is make sure that these cars are removed once we verify that they are have been in our respective jurisdiction for a point of time. 60 days is the time frame that they can remove them off of the streets and have that respective jurisdiction to take care of that because they're a nuisance to the respective neighborhoods from that standpoint. I'll stop speaking at this moment, and I'll give the mic over to my respective jurisdictions, the folks that lead in transportation, but also our government relations, if I can, Mr. Chair, and hope for a favorable report with 357 as we bring you the letter of support from the delegation.
Thank you very much.
Yes, sir.
Welcome.
All right. Good afternoon.
Just go to the podium so
Sure.
everyone can see.
Right. Good afternoon, Vice Chair Waldstreicher, members of the committee. My name is Nina Themelis, Director of Government Relations for the Mayor's Office in Baltimore City, here to testify in support of SB 357 on behalf of the Baltimore City Administration. As our senator said, the SB 357 would authorize the city of Baltimore to tow and impound vehicles who are not properly registered in the state of Maryland, owned by residents who have lived in the state for more than 60 days. Statewide registration requirements are in place to ensure that vehicle owners are in compliance with critical state motor vehicle laws like vehicle emissions testing, insurance requirements, ensuring compliance with administrative penalties for citations, and other important measures intended to promote public safety on our roadways. Last year in 2023, the Baltimore Police Department stopped 5,135 vehicles with out-of-state license plates, which account for approximately 14% of stops captured by our ETICS program, which is our electronic ticketing system. That number does not represent any paper tickets, verbal warnings, or other stops not documented on ETICS. 5,335 citations and 7,167 warnings were issued out of those 5,135 vehicle stops with out-of-state tags. About 465 vehicles with the same license plate were stopped multiple times. Additionally, the Baltimore City Department of Transportation issued 34,555 parking citations to out-of-state vehicles in 2023. Over 56% of those citations were from one state alone. Finally, for automated speed and red light camera citations, there are thousands of citations that are issued to vehicles with out-of-state tags. Baltimore City currently doesn't have any mechanism by which to require those who receive citations on out-of-state vehicles to pay those fines and comply with state law regarding such citations. While Baltimore City does enjoy the benefit of having frequent out-of-state visitors, there is still a significant number of vehicles registered out of state that belong to Maryland residents. So for those reasons, we respect a favorable report on SB 357.
And I'm just here for the any questions.
So thank you, Chair. Senator, this question's for you, sir. They're gonna ask you to get up there.
I mean, you ready?
So McKay to McCray or McCray to McKay. I'm not sure how that.
Brother to brother.
Okay. So you are aware that in Annapolis, almost 188 people come and work in Annapolis for 90 days.
I'm very aware.
So I am sure that in Baltimore, there are people who come to Baltimore for 3 or 4 months at a time to actually work and stay in a B&B or stay in wherever. Has there been some kind of a thought that says you got a temporary doohickey to put on your car that says you're legit compared to, I understand the problem. I support the bill.
Yep.
But I'm afraid you're going to cast a net, and that's not going to look good for Baltimore when somebody's trying to have a temporary job.
All right, so Senator McCray, not to be confused with Senator McKay. Yes, this has been given a lot of thought. We've actually been working in concert with MVA. And not only are folks that may work for a long period of time, but actually don't reside in Maryland. So let me be clear, but you have folks that may be going to educational institutions that do not have to register at our respective state. We also have military that come, you have BRAC, you have things of that nature that don't have to register within our respective state within a 60-day period. There are mechanisms already in place with the MVA as they're investigating some of these types of cases. What we're doing is we're trying to get them off of our streets, but there are already mechanisms to investigate those folks that do not live in the state of Maryland for a 60-day period, have ghost tags, and make sure that we move them in the right direction.
Okay, thank you.
Thank you, Mr. Chair. I'm sort of obscure over here.
Yes, sir.
My name doesn't rhyme with McCray, but I've got a question anyway. So, well, just a matter of interest. Why do you need a statute from the Maryland General Assembly passed into law by the state of Maryland to authorize Baltimore City to tow cars on city streets which are in violation of law? Can't the city pass an ordinance to authorize the city police department to do that?
I would assume not. That's why we came to the state jurisdiction.
Do you know the answer to that?
Yes, so the Baltimore City Law Department has opined that because these violations are in reference to the registration of the vehicle versus a parking violation, that we do not currently have the authorization to tow or impound those vehicles.
Interesting. Okay. Maybe we should pass a more broad ordinance or law like Senator Bailey had a couple of minutes ago on golf carts to authorize local governments to do this kind of thing, rather than have on a one-off basis, different jurisdictions come to us and ask for this. Just an idea. Thanks.
We talked about that all the time, although I do love the golf cart hearings. Senator Folden.
Thank you, Mr. Chairman. Hey, welcome back, Senator.
I am. Not flow.
So I just want to be sure I'm understanding this correctly. So this legislation is aimed at removing these ghost tags or people that are in the community, however, for more than 60 days, and would provide authority to deprive someone of their property for a tag violation.
It was. So first, these are folks that obviously are not doing their due diligence by registering the vehicle within the 60 days. We already told we do have tow scenarios. So like if you park your car for a significant amount of time or things of that nature, or it's derelict and it's on the streets, this will still be impounded. It will be removed off of the respective city streets. If a person has a certain amount of speeding tickets or parking tickets and things of that nature, we would still be able to impound and remove that car off the street. This will put that in that posture.
So I guess my question is, for example, how are you able to monitor this to say that they're here? Because I know working in Baltimore City, I know a lot of people come in from Pennsylvania and work there, and they're there every day, and they work into the evenings. You have some military and you have students that come into Baltimore, and they're from all out of state, and they're there for longer than 60 days, and their car may be there the entire time. The residency requirement is normally that threshold over 6 months out of the year if you change residency. Like we have a lot of snowbirds between here and Florida. So my question is MVA is not equipped, and I don't know how this system would be different to separate out in a separate data system that says, oh, well, this is a visiting college student, or this is a Pennsylvania resident, or this is a military service member. Like, you started to touch on that a little bit, but there's no separate database that shows that either of those issues would be the situation.
I'm gonna let
Yeah, sure.
DOT comment, but I would definitely say that over at MVA, what was expressed to me by the administrator, that they do have an investigation unit specifically for these situations. That notification does go out to the respective person that is being investigated.
Sure.
Without the respective tag. So there is some level of a process. I'll let him step in.
Thank you.
Thank you, Senator, and great question. What we're actively discussing is a flagging system.
I'm sorry.
Oh, excuse me.
Are you?
Liam Davis, Legislative Affairs Manager for Baltimore City Department of Transportation.
Okay.
Thank you.
Thank you.
So what we envision in terms of the enforcement, we have license plate reader vehicles that go around the city, and we can identify an out-of-state tag and flag an out-of-state tag. And when we do that, we anticipate our TEOs, our traffic enforcement officers, will actually place essentially a repair order or a repair order ticket, something similar to that. It's like a notification. It's not a citation saying, hello, your vehicle has been flagged as being out of state. You can follow up at this number or at this email to verify whether you're an out-of-state student, military, someone who is working from out of state legitimately. And we're committed to building out a database where that can be linked with that flagging system to verify that the tags are.
So what if they don't want to respond to you? Because that's kind of an overreach of government authority to just arbitrarily go around because it's an out-of-state tag to mark somebody's vehicle. I mean, wouldn't that be, I don't know, borderline tampering with motor vehicle?
I don't believe so, because
it's their property.
The license plate reader is a vehicle that is already.
I understand that, but you said then they would have to stop if they sell it however many times within a certain time. And I don't know that your traffic enforcement people work overnight. They're not working midnights. They work early mornings. They work into the twilight. Fair? Is that fair?
Yes.
So they're not working overnight. So they're going to see these same vehicles in locations around the city for extended periods of time. And they're going to now, after seeing it so many times, get out of the vehicle, issue a piece of paper and stick it on the vehicle. Is that what you're telling me?
I'm saying that when a vehicle is flagged in the system, we will have the option of issuing a repair ticket, essentially saying you have been flagged as being out of state. And in order, you can verify by contacting this information, using this contact information.
And that's my point. So if they choose to say this is ridiculous, I'm here legally, I'm here working, I'm here on the military, I'm here as a student. They have now touched my property, put something on it. I'm not calling them. I don't have time for that nonsense. If they don't call, you're going to deprive them of their property. By the way this is written, if they fail to notify, which there should be no requirement for anybody to respond to something that has no real, it's questionable legal authority to be on their car in the first place. If they don't respond, you're telling me that after 60 days, you're gonna deprive them of their property that they own and pay for. And if it is mistakenly by your department, is there a mechanism in place to pay back the tow fee of the deprived property? Like, is there a fund set aside? Because I don't see any penalty on this. What's the penalty other than the tow? Is there a fine?
So in the event, I can say this, we do have the ability to release a vehicle and waive any fees in the event that a vehicle would be improperly impounded.
Okay,
that's an option.
But still, that's a nuisance. You've now taken, like, I know that my good friend here from Harford County spoke about one time when she had her car towed in Baltimore in the middle of the night, and she was 21 and she was petrified to walk around the city. So now we have the potential of removing someone's property that they own legally, that is legally parked, except because your traffic monitor has gone around and flagged it and they didn't respond, or it was taken off their vehicle and they didn't know to respond. How are you gonna, how is this a viable solution for what you're trying to do by trying to find a mechanism to legally deprive someone of their property?
So Senator, what I can say is that we will be working with the MVA as they have the database that would allow us to see vehicles that are registered with out-of-state tags to individuals who have Maryland licenses. The process isn't defined because we don't have the authorization yet. We are committed to working out a process that would not deprive somebody unreasonably of their vehicle or access to their vehicle.
I believe that you just answered my concern then. That is, you're trying to put the cart before the horse. You're trying to put a solution in front of the actual methodology to get to that point. So I don't think it's appropriate to bring this measure forward at this time without having the proper mechanism and notification process that we can be aware of and be comfortable with ahead of that time. That's all. I appreciate it. Thanks.
Thank you.
Thank you very much. Just as to any one of you, so I can understand how it works. Whether I'm new on a job or I work part-time, full-time, once those cars are tagged or by the system, it goes into an automated system, is that right? And it will come up anytime someone is looking, someone who is at work looking to see if the officer should this car be here, they can look and see this car's been here since, I don't know, 90 days, 100 days. You issue it, they respond and do not. If they respond, they have to what? Prove, and how would they prove that they are residents of the city? Because I understand what you're saying. I'm for the bill. I think that if they're there and they're getting they're not paying the right taxes and they're getting all of the amenities of the city, then somebody else is paying. And I don't know what another way is, because we have that problem in my county, in my district, where they come in, they never change addresses, and they stay and then and on it goes. And as far as I'm concerned, when that happens, they're taking advantages of services that someone else is paying for. When it's told, a person comes in and does what to prove that they are, was it a gas bill, light bill? What do they do to prove that they're a resident?
So, just to be clear, they would be proving that they are not,
that they live legally in Baltimore City.
So
not,
if they
should have had their tags transferred.
Yeah.
I mean, what do they say that would?
So
you say, oh, gee, we got the wrong person.
Well, if they show proof that they are a permanent resident and they have been towed for not having the vehicle properly registered, then they would be in violation. If they failed, I would say if they were able to show, like, there's a variety of different items that we would request or take to verify if a person is legally parking on the street and not skirting state registration laws.
And if one is skirting the law, what then happens? What's the penalty? You find them, you tell them get out, you tell them get a new, you give them a certain time to have their registration and license changed. What happens? What's a penalty?
We would impound the vehicle, and then it's really in their best interest.
So you would impound it until that person actually went down.
My understanding is they could get a temporary registration.
Okay, but you get
and then
you get in one day, right?
And we would work with you know, we're reasonable here, and we understand the concerns with people who commute to Baltimore to work, who are out of state students. We're in no way attempting to deter any of that.
Because like I said, I have that problem, and I should have amended myself onto the bill. But okay, thank you, thank you, Mr. Chair.
I just have one follow-up.
Man, I'll let him ask this question.
Thank you, Mr. Chair. I just have a follow-up because he just brought it up and it was something that I actually didn't even think about. What? I didn't think to ask, I guess. So you bring up that they're towed and they potentially will be impounded until they resolve it or get a temporary tag. What is the cost of a tow fee in Baltimore City when it's summoned by the police? And what is the daily storage fee?
I can get that for you.
Because you've taken away their mode of operation to get to a facility. You've taken their registration card from them because it's usually in the glove box. And you're requiring them then to go to MVA to resolve this. But you've deprived them of the property to expeditiously solve. So how much is a tow? How much is the daily impound fee?
He'll get back to you with that information. I did want to lean back in and say, like, there's already provisions, but this will be an added provision in reference to making sure that we're protecting our citizens from that. So the information that I got from Administrator Nizer is they have an investigation unit, as stated previously. The investigator actually goes to the home of the address that's notified on that specific space. They leave notification at that address if they don't answer the door or if they aren't there. They actually come back if they do not. And they're also have the ability already in statute to be able to find if that car is sitting there and they're not doing their due diligence within a 60 days. So even if they don't respond, there are consequences of not responding. The second piece that I will lean in is the furthest that we can stretch. We can even take the out-of-state tags. So those things already exist in statute.
Taking the tags from somebody is entirely different than taking their property.
I just say you gave the insinuation that there isn't a penalty already that exists if you are breaking this law. So I wanted to lean in and say that there's a fine that can be paid. There's also your tags that can be removed, and this will be added to that situation.
Well, okay, Senator. So you're telling me that there's a mechanism in place currently to take someone's tags off their vehicle?
That's exactly what I'm telling you. And that
under what circumstances? For just an out-of-state
just
vehicle?
the out-of-state tag.
I've never heard of that law.
Well, I would ask you to educate yourself with the Motor Vehicle Administration because it currently exists in statute at this moment.
Well, I would love to see that because I've never seen a law that allows an officer or anyone to remove a legally registered
We're
tag.
both legislators. So I told you that the agency that did it, I'll forward you the email, the correspondence that I have from our administrator explaining the entire process for out-of-state tags. But as stated, I'm gonna repeat it for you. They go out and they investigate. They go to the address that they have on hand. They then come back a second time. If they come back a second time and you do not respond, you have the ability to be fined. The fine can go as high as $500. And under the most egregious, we can actually remove the out-of-state tags. Those exist right now.
I look forward to that discussion because I don't know of any circumstance that allows an officer to remove a registered plate that still is valid by registration year.
Because you don't know don't mean it don't exist.
I appreciate that. I will look forward to that email.
I'm gonna forward it to you.
I would love to have it today.
You're in the global system. I will.
Thank you.
Thank you, Mr. Chair.
Thanks. Well, I'll tell you one thing. Thank you both for being here. I have, for one, never seen an exchange that heated over license plates before. But look, I did have a question though. So given all the steps that were outlined, and I may have missed this, so I apologize. So is it just it's just a, you can fine, you can ticket, you can remove the license plate. So what are you running into? I mean, what's the problem here? I mean, so you the cars are just still there and you can't, what is the problem that, because it seems like there are a lot of drastic measures that can be employed. I'm just trying to figure out.
So it's a couple of them.
I know, sorry if I missed that at the top.
No problem. One of them she talked about with the electronic ticketing piece of it and 14% being out-of-state tags and 50 of them come from one jurisdiction. The other piece is as we begin to purchase more cars, so people used to have one or two vehicles. Now that you have multiple vehicles, there are multiple out-of-state tags that's sitting in a number of our neighborhoods where people aren't driving. They're sitting on our streets and our neighbors are complaining to us saying they know that this tag that they know the law that you're supposed to register within 60 days. They know that these people live at the respective address and they don't see where government's enforcing that mechanism within law.
One of the problems is a fiscal problem because that means the city is not getting, and the state really, we're not getting the money when they go down to exchange their tags and then to renew those tags yearly the state is out of a lot of money.
You're absolutely right. There was an article on a national standpoint, but they call them ghost tags. So
Right,
because
right, that's
the
right.
revenue isn't coming back to the respective jurisdiction, there's a lot of different loopholes that's happening.
Mm-hmm.
So this isn't just relevant to Maryland, but there are the adjacent jurisdictions that are dealing with it.
We need all the money we can get. I'm voting yes for that. Thank you. Thank you, Mr. Chair.
I'm going to make sure that I send that email, not just to Senator Folder. I'm gonna send it to committee staff from that standpoint. So, yeah.
All right.
All right. Thank you. Appreciate you, Senator. Thank you very much to the panelists. And with that, that'll conclude the hearing for Senate. Senate Bill 357. We'll now move on to Senator Kelly with Senate Bill 42.
Thank you, Mr. Chairman. I'm going to have my panel come up now to keep it moving. Is that okay? Yep, perfect. I will start talking. I'm actually going to have my intern Riley Blaugrand, who is a public policy student at the University of Maryland, introduce this bill, but I will remind the members of the committee that we voted for this bill unanimously, including Senator Charles, end of last session. Senator Jennings actually had some ideas to improve the bill when it got to the floor, and we ran out of time. So this version includes the changes that Senator Jennings suggested. One was just a change from the word primary purpose to solicit in the language of the bill, just to ensure that private property farm would not be included. There's also the elimination of the exemption for the language around Western riding. We determined that that was not necessary in conjunction with Senator Jennings. There is also an amendment that you will have in your file from the Maryland Horse Council that will be explained that clarifies the requirements around therapeutic riding for children who require alternative helmets. But with that, I will just remind you that we've all voted for this. Riley will introduce the bill, and then we do have a panel here. I've asked them all to be very brief in their testimony because it's late in the day and we've already voted this bill out of committee. Thanks.
Hi, Chair Smith, Vice Chair Waldstreicher, members of the committee. SB 42 is a public safety and a public health bill that establishes a requirement for minors to wear a helmet when riding a horse under certain circumstances. You will remember this legislation from last year when the committee voted unanimously in favor when it came over from the House late in session. You may also remember that the bill received some questions from Senator Jennings on the floor last year, and we ran out of time before we could address them appropriately. Over the interim, Delegate Laham worked with Senator Jennings to address his concerns. Delegate Lehman's team and advocates worked with Senator Jennings over the interim to make the necessary changes to better protect Maryland's youth riders while also allowing appropriate flexibility on private property. This legislation requires minors to wear a helmet when riding horses on specific property. This includes highways, a public horse riding path or trail, and the grounds of a facility that solicits or offers educational, recreational, or competitive equestrian activities. There is a sponsor amendment to this bill to address therapy incorporating equine movement. The amendment ensures that children who are receiving occupational, physical, and/or speech therapy incorporating equine movement as a treatment strategy and are able to wear the standard safety helmet are required to do so. For children receiving therapy services from a licensed medical provider for whom the use of an alternative helmet is necessary and appropriate, a helmet in compliance with the provisions of the Professional Association of Therapeutic Horsemanship's international guidelines for alternative helmet use must be used. Children with disabilities participating in adaptive, sometimes called therapeutic, horseback riding lessons are already covered by the language of the section referring to the educational and recreational purposes, since that is the purpose of their riding. This bill is critical to protecting Maryland's youth because research shows that head injuries are the most common cause of prolonged hospitalization and death due to horseback riding. In fact, 39% of all riding injuries occur in riders under 19, with the risk of severe injury higher than in a sport such as American football. As many as 21% of young riders are injured in a given year, and 25% of lethal sports injury in children are caused by horseback riding. Concussions and other types of traumatic brain injury prevention are receiving significant attention in sports overall, but it is especially important to minimize these injuries in children, given their potential for life-altering consequences for both the victim and their family. You can look back to your file for testimony from Promise Landing Farm, Maryland Department of Health, American College for Emergency Physicians, Maryland Farm Bureau, Maryland Horse Council, Brain Injury Association, and the Maryland Association for Wildlife Conservation. By considering and voting to advance this bill, we will be doing our legislative duty to protect young Marylanders. Thank you for your consideration. I urge a favorable report on SB 42.
Want me to go next?
Whoever wants to go next.
Good afternoon, Mr. Chairman and members of the committee. My name is Jane Sigler, and I'm here representing the Maryland Horse Council, which is the trade association for the entire horse industry in Maryland. Our written testimony contains a lot of data and facts and figures, so I won't go into them here. I just want to mention one data point in particular, which is that 16% of Maryland horse owners and 33% of Marylanders who ride but don't own the horses they ride are under the age of 18. And in Maryland, about 500,000 horse households contain at least one person that owns a horse, rides a horse, and is a horse enthusiast. So the Horse Council supports the bill, and we also support the amendments that will cover the application to therapeutic circumstances and services. We urge you to give a favorable report. Thank you.
Good afternoon. My name is Victoria Pickett. I'm a junior member of the Maryland Horse Council. I've had horses, been working on my family's working horse farm since I've been 6 years old. So I know a lot and have decades of a decade of experience. I'm here to advocate for the importance of enforcing helmet use for our youth equestrians in Maryland. I'll be brief. Our horse community has embraced prioritizing safety through correctly fitted and in regulation helmets. Passing this bill would reinforce this commitment, preventing countless brain injuries and ensuring the safety of our future equestrians. I urge you to consider the gravity of this matter. Enforcing helmet use for youth equestrians is not just a matter of safety, it is a commitment to the well-being of our community. I encourage you to support and pass Senate Bill 42. This would be a significant step towards a safer future for our youth riders. Thank you for your time and consideration.
Hello, I'm Barbara Salner-Webb, lifelong Maryland resident, a small farm owner who loves to enjoy Maryland's beautiful green areas, especially while out riding my sweet horses. Always, of course, wearing a safety helmet. For years, I have supported Delegate Lehman's important legislation to get a helmet bill for minors riding on public lands, which is a brilliant public health initiative. Almost every equestrian has had or knows someone who had a, quote, freak accident, where possible serious brain injury was averted or at least minimized due to the rider wearing a helmet. I personally would likely have been permanently impaired, if not killed, in a bad horse accident years ago, were it not for the protection from my helmet. And for decades, all rides that I have organized have required that everyone wear a helmet, and I've always encouraged everyone to wear helmets whenever they ride, especially minors. A recent University of Connecticut study showed that helmets reduce the possibility of death by head injury by 70 to 80% in horse riding. And a recent survey of Maryland horse riders affirmed that well over 90% support requiring helmets by minor riders. Since helmets are required for children riding bicycles, surely they should be required for children or for youths riding horses as well. So to protect Maryland youths from suffering serious brain injury while riding horses on public lands, please pass SB 42 or HB 113. Thank you for your time and attention.
Good afternoon, Chair Smith and members of the committee. Thank you for your time today. My name is Alex Sossenkale, and I'm here as the Legislative Chair for the Maryland Youth Advisory Council. Senate Bill 42 reflects a pressing issue concerning the safety and well-being of our young equestrian riders in Maryland. From Native American culture to therapy and sport competitions, it's understood to be a core aspect of many Marylanders' lives. As a Native American, I've grown up around this culture, understanding all the joy and wonder it can bring. With that, there are also risks, just as with any activity. Because of that, the CDC highly recommends the use of helmets, specifically with a standardized safety design, which this bill directly addresses. Aligning with the following priorities in Article 4 of Health and Social Issues, Clause F and P of the Council's legislative platform, the Council has voted in favor of endorsing Senate Bill 42. Senate Bill 42 is not only a step toward enhancing safety of young equestrians, but also represents the diverse heritage of horseback riding within Maryland. Through this legislation, we align with best practices in safety and take a significant step towards preventing avoidable incidents and injuries. The council believes in the duty of the Maryland General Assembly to pass legislation which will create a safe and healthy future for our generation. And for these reasons, the council supports Senate Bill 42 and respectfully requests a favorable report from the committee. We thank you for your consideration.
Good afternoon, everyone. My name is Regina Welsh. I'm a Baltimore County resident and lifelong horsewoman. I've served in a leadership and boots on the ground roles in equine-based organizations, including the North American Point-to-Point Association and U.S. Pony Racing for the last 22 years. Both of these organizations were dedicated to promoting pony racing and horse racing for young riders with safety as a major focal point. Additionally, I have been a licensed steeplechase trainer of racehorses since the late 90s. Maryland has one of the largest horse populations per capita in the country and is unique in that it is the only state which has a program for youth pony and horse racing. In my field, I've witnessed how the use of a riding helmet saves lives and or has provided for a better quality of life to anyone sustaining an injury while riding. I host riding clinics and give riding lessons to young individuals in riding arenas, but largely outside of the arena in a cross-country setting. I have seen firsthand children walk away from a fall while riding only because they were wearing a helmet. Unlike other helmet requiring sports like football, cycling, etc., horse sports involve animals with a mind of their own that outweigh their riders by hundreds of pounds. So aside from protecting a rider's head from impacts sustained from a fall, helmets also protect the rider's head from being stepped on or struck by a horse's leg or foot. I require a helmet to be worn by adults and children anytime they are on a horse or pony on my property and at any event that I organize or manage, and my colleagues have the same requirement. If this law is passed, Maryland would join other states like Florida and New York who have similar laws which have been in practice for several years now. And most importantly, this bill would help ensure the safety of children and newcomers to the equestrian sports. Thank you for your time. Oh, no, she's good. We're good for questions. We're done.
Excellent. Thank you very much. Alex, you were once a page, were you not?
I was.
Was that last year?
Yep.
Yeah, hey, welcome back. I'm glad you're still engaged. That's awesome.
Thank you.
Good stuff. I will say that Senator Kelly, I just can qualify. Delegate Lehman furnished what I thought was the most epic answer ever to a question with regard to this bill. It's no longer referenced in the bill, but it was Western style riding or Eastern style riding. Remember, someone asked her, "What is Eastern style riding?" She said, "I don't know, the opposite of Western style." It was so funny. Anyway, it's gone out of the bill now, but that was great. I will always remember that. Anyway, Senator McKay, go ahead.
Senator Kelly?
Yes,
for
sir.
you, please.
Oh dear.
Yeah, no, it's okay. So, why aren't we requiring anybody, adults as well, that they should be wearing a helmet when they're riding a horse?
That's a great question. Does anybody have an answer? I mean, this is Delegate Lehman's bill, you know that. So I would say that this is modeled after the laws in Virginia and
New York
right?
and Florida.
I'm sorry, New York and Florida would be my guess. And I would also, if I'm guessing, based on having done a lot of public health things, well, I don't know, because the bicycle helmet
After
laws.
bicycles also.
Yeah, after bicycle helmets. Yeah, yeah.
So
I-
that would be a good
Answer
to
to
find
have.
out.
Yeah.
That why we don't require that for all adults. Second question is these helmets. Is there a rating system for them of?
There's standards. Oh, looks like Riley has an answer.
There's international guidelines for helmets, and then the amendment brings in there that if a person is not able to wear a helmet, like one of the guideline helmets, there's another guideline for different types of helmets that people with disabilities who cannot wear a traditional helmet have to wear.
Right, but is there a rating on I'm gonna call it like a crash rating? So if you're at a horse that is riding at 5 miles an
plus
hour
minus.
compared to 35 miles an hour? Is there a rating of these helmets?
Luckily, we have an expert here.
As the bill refers to, I think there's an organization called the American Society for Testing of Materials or something like that. They test helmets and they certify them as being safe. They drop them from heights, they run over them with tractors or whatever. So they are, if it's an ASTM approved helmet, it's approved for any equine sport.
You wouldn't know at what speed the max is.
I can
them.
find you that. There's ASTM and also Virginia Tech has a helmet lab where they test football helmets and all kinds of helmets. And a year or so ago, they did a study of equine helmet. They tested a bunch of equine helmets and rated them for different kinds of impacts and things like that. And I can get you that as well.
I'd be interested in knowing a little bit about it. My understanding is the only standard is that there are no helmets that are rated more than 35 miles an hour of an impact.
I do not know that. I do not know that. The horses,
the committee, I support your bill, so please don't read into this at all. But it's important to understand that helmets, unless we can get some other information, helmets are only good up to 35 miles an hour. Just think about that.
Most horses don't go that fast. I mean, thoroughbred race horses on the track can sustain speeds of close to 40 miles an hour for 2 minutes.
I understand that. My point is that the rating systems of helmets are not more than at 35 miles an hour. So
yeah,
unless I can help. So thank you.
Yeah. You're welcome.
Okay.
Well, Ms. Solner Webb, I'm glad you were wearing your helmet. So
am I.
I'm glad you were here to present.
It's shattered too.
Yeah, I'm glad you were wearing it. Oh, thanks. I know. No. Well, Senator Kelly and panel, thank you very much. Thank you all very much for
Thank you so much.
All right, with that, that will conclude the hearing for Senate Bill 42. We'll now move on to Senator Wallstreicher, who has the next two bills. Senate Bill 149 and Senate Bill 77. Which one would you like to take? All right, we'll go with Senate Bill 149.
Thank you, Mr. Chairman, members of the committee. Senate Bill 149 will go fast. Towers tow cars for a lot of reasons. There's an accident or it's parked illegally, but a surprising amount of the business is cars that are simply abandoned on the road. They are then go to the tow lot, and after a period of time that indicates that, yeah, no one's coming to get this car is definitely abandoned, the towers have to take a series of steps to notify people. They have to notify 3 people. Obviously, they have to notify the owner of the vehicle, the owner of record, and they do that through certified mail over a period of, I think, 3 notices. They have to notify the insured, meaning the insurance company like State Farm or Geico, and they have to notify the underlying lender, meaning the bank that technically owns the vehicle, like Bank of America or whoever lent the money to purchase the car. In previous years, we've passed bills allowing the notification of the sophisticated parties like the banks to be electronic. Insurance companies are also sophisticated players and can also be notified electronically. This bill simply allows the insured or the insurer of record to be notified by the tower electronically. It doesn't change with regards to the owners. Owners obviously have to be notified by certified mail. That continues in this bill. With that, I will turn it over to my panel.
Thank you, Mr. Chairman, members of the committee. Andrea Mansfield with Manis Canning and Associates representing the Towing and Recovery Professionals Association. Really want to thank Senator Wallstreicher for introducing the legislation. I'll be extremely brief because Mr. Parrish will be able to answer any questions and give some more specific details, but this is really about just streamlining the process, allowing for the electronic notification. There were 2 bills of the last 2 sessions that have been voted favorably out of this committee to allow for the electronic notification. This is just simply extending it to the insurers of record.
record as the sponsor indicated. With that, we would encourage a favorable report. So thank you.
Good to see you. Good afternoon, Charles Parrish, Mr. Chairman, Committee, Legislative Chairman for Towing Recovery Professionals of Maryland. I brought an me too on everything that's been said. I don't want to go over it too much. MVA also already has a mechanism in place to where insurance companies are required to give a notification address for us to use. Instead of that mailing address, they could simply put in an email address if they opt into it. This bill allows them to opt in or not participate. But I did bring an example of something, the letter that I sent out myself on January 25th of 2023. I got it back on August the 23rd of 2023. It was mailed out of Baltimore and it went to Mafe in Annapolis. And what's happening is these vehicles, not only for the towers that are being sit in the yard, that price is going up. Insurance companies, the consumers, a lot of times, as we know, a lot of addresses that are associated with VINs, the registered owner doesn't live at that address. But the insurance companies and the lien holders will get theirs and they'll notify that resident, registered owner of the vehicle. They contact us and it keeps their fees lower. So this is an actual mailing that happened in today's time, which, believe me, I need help with an iPhone, but electronic way. I'd appreciate a favorable review. Thank you.
All right, thank you, Senator. Questions from the committee? Seeing none. Easy peasy. All right, thank you all very much.
Thank you.
Thanks.
Thank you.
Sorry, sorry, Senator. That'll conclude the hearing for the video chop.
Yep.
That'll conclude the hearing for Senate Bill 149. We'll now move on to Senate Bill 77, Senator Walstreicher.
Thank you. I think this bill will be similarly quick and easy. We're going to hear from our bicycle activists and advocates, and they do a great job representing their cause. And I agree with their framing and the way they approach these issues that come in front of our committee. But I come today less from an ideological perspective and more with a personal story. So what this bill does is it changes the default for bicycles on sidewalks. And under current law, bicycles are not allowed on sidewalks, but the locals are allowed to allow them. This changes the default and says bicycles are allowed on sidewalks, but the locals can ban them. And when I grew up in Montgomery County, I don't know if they were allowed or not allowed, but in between my sophomore year and my junior year of high school, all my friends were getting their first jobs. I didn't come from an affluent area. People were eager to work, make money, pocket money for themselves, maybe help support their families. And in between my sophomore and junior year, I did that, and a lot of my friends did that. Except I have a late birthday. Back then, the cutoff for school was December 31st. And so while most of my friends had their driver's license and were driving to their workplace that summer, I could not. I didn't have my license yet. And so I rode my bike every day to work. It was about, 4 miles or so. I really enjoyed that time. As much as I was jealous of my friends who had cars, I enjoyed it. I was not a bicyclist hobbyist. I probably didn't wear a helmet back then. I certainly didn't wear the Lycra. I was just trying to get from my home to where I needed to go. I didn't feel comfortable on major roads in Montgomery County. I rode on the sidewalk and it was fine and it was safe. And if there was a pedestrian, I slowed down and went around them. And there were no issues. And for 3 months I did that, and I continued to do that into the fall just to get places before I got my driver's license. And tons of folks are not hobbyists as cyclists. They just want to get from here to there on their bicycles. And oftentimes the sidewalks is the safest way to do so, as it was for me. So if your local prefers not to do that, this continues to allow them to do this. But if your local is okay with this changes the default for everyone. And with that, Mr. Chairman, I ask for a favorable report on Senate Bill 77.
Good afternoon. My name is Josh Feldmark. I'm here representing Bike Maryland. We represent the cyclists across the state and Sure, why not? We also represent the unicyclists. I'm pretty excited about that, to add them to our membership roles. As you heard the sort of explanation, I just wanted to sort of really, by way of example, tell you that right now, if you are a 10-year-old trying to bike to her school, if she is on the sidewalk, she is breaking the law. If she is in the middle of the road, she is complying with the law as it is written. Same with my 77-year-old mother, who does like to ride her bike from time to time, but I assure you, she does so on the sidewalk where she is safe and is not impacting anybody, as opposed to in the road where no one is safe with her biking on the road. The other thing that I want to clarify is you are going to hear a little bit later from a person that is part of our advocacy team that we love, but is asking for a change in this bill that it would continue to prohibit e-bikes on sidewalks. And I would just tell you a couple things. One is it's still up to the local jurisdiction, and let them sort of decide what works. The other thing I will tell you is without any sort of differentiation between e-bikes, you've got there are 3 types of e-bikes, and level type 1 and type 3 e-bikes. If you're not pedaling it, they're not going anywhere. And it's actually type 2 where you have a throttle and you don't have to pedal. And we would say that if you have to pedal to make the bike go, that they should continue to be on sidewalks because they're really mobility devices. And with that, I would just urge a favorable review.
Hello, John Corrin, Bicycle Advocates for Annapolis and Anne Arundel County. I also served on the 2017 Bicycle Safety Task Force created by the legislature. And here in Anne Arundel County, an ordinance was passed a few years ago that is identical essentially to this bill that we're proposing statewide. We checked with Montgomery County first, which has allowed this for decades, and no reports of issues between bike riders and people on foot. Howard County has also allowed this for a long time in most places, but they prohibit in historic Ellicott City where there are narrow sidewalks, crowded with pedestrians. And so it's a good example of a locality making the local decision about where there might be places that ought to be prohibited. Come to discussion about other types of devices like e-bikes. Leave that to the locals as well. The locals will have full power under this bill to make decisions about where to prohibit based either on location or by device. If a locality decides we think e-bikes are unsafe in this area for a certain reason, it's fine. I find e-bikes to be accessibility devices. Most of the people I talk to that ride e-bikes tell me the same thing. If not for this, I would not be able to ride a bike anymore. So there are folks that rely on them for both recreation and transportation, and we should not make a sort of a sweeping decision to deny them. What we should do is regulate the behavior. We should regulate, you've got to yield. You've got to yield to pedestrians, you've got to yield to people using assistive mobility devices. And that's why we make that into the bill. Thank you. I hope you'll find favorable view of this bill.
Excellent. Thank you very much. That'll conclude the testimony for the proponents of the bill. We'll now turn to committee for questions to Senator McKay and then Senator Muse.
Thank you. Senator. So right now, the locals have the ability to change.
That's
either
correct.
opting, in this case, opting in to allowing it. The locals have this.
I think we're on the
opportunity.
same page, yes. Under current law, locals can allow bikes on sidewalks.
So what examples are we having that are giving that we're not happy with the locals already addressing this issue, either getting in or getting out? And why does it need to be a state? I mean, if there is an example, was there an accident? Did somebody get hurt? Whatever the case may be, if the locals already have the option, I don't understand what the necessity of the bill is.
Yeah, so I just think that as a matter of policy, we just got it reversed. As a matter of policy, sidewalks are the safer place compared to the roadways. And so sidewalks should be the default. And if our locals make a policy decision otherwise, they can do so. And so I just think the default got backwards policy wise. But I'll leave it up to my advocates if they have stories from their members that they perhaps may have heard of on this issue.
Yeah,
You want to come up?
Sure. The main issue we're facing is that a lot of the locals don't really know about this, and so it's sort of an indifference to changing it. I have anecdotal stories, I don't have numbers, of folks, and it's not usually major issues, right? It's a cyclist on a sidewalk who gets sort of talked to or notified from either the police or from some other sort of authority figure. And it's also folks who are aware of this law, who are cyclists, who are just saying, I'm not going to be on the road because I don't want to break the law. And so we talk to the locals when we can, but we're only so many places. And so
I don't understand the comment of not being allowed on the road. We have the share the road signs, to be perfectly honest, so many of them that they become as many as trees along the road of share the road and all that kind of stuff. So is that program not, the locals have to opt into that program? It's not a default?
No, I'm sorry if it sounded like, if I accidentally said that whether or not bikes are allowed on roads. Bikes are always allowed on a road unless it's a limited access. The issue is that most folks, unless you're a serious cyclist, don't feel, and sometimes aren't, safe on those roads. And so they would like to they would like to bike on the sidewalk, but the law says they have to be in the road where they don't feel safe because they're unsteady on their, not steady enough on their bike.
Right, and I get the impetus of the bill because we want to have safety. But coming from a community that have high percentage of elderly people, this is a problem on the sidewalks, that the sidewalks aren't for pedestrians anymore. And that, well, I've got, if it's going to be the default, I tend to believe that the default should be the way it is right now, because just as we want to protect those people that are cycling, I want to protect the 74-year-old who's walking on the sidewalk and now has a cyclist come up upon him, which most cyclists are courtesy. But I'm already dealing with skateboards. I'm already dealing with the uniboard or whatever. I'm dealing with not so much mopeds as much, but those type of things. And now you want, in my mind, to add more traffic onto it.
Josh.
And I don't see how that outweighs the safety of the elderly pedestrian.
Yeah, when we introduced this idea here in Anne Arundel County, we encountered exactly that concern. In fact, I went and met with our Council on Aging and Disabilities to discuss that issue, not just for the elderly, but also for people in wheelchairs, people with walkers and so forth. When we went and checked with Montgomery County, which has permitted this for a long time, they reported to us that they just did not have issues. They just had not even anecdotally heard of issues. Are you going to run into the kid on a bicycle, the school kid on a bicycle that may do something reckless near a pedestrian? Of course, but there again, that's why we put the yield to pedestrian provision in here. So it's not so much the device that creates the threat. It's if somebody's going to ride recklessly, which, they could do on almost anything.
Well, and I thank you for that answer.
Yeah.
But I could apply that the other
I-
way.
yeah, that's
So
right.
I get it there.
Yeah.
And then, look, for all disclosure, I rent e-bikes. They don't belong on the sidewalk. Even if they don't have the throttle, if they're 1, 2, or 3, they don't belong on there. Just for the simple fact that the person who is actually riding that bike, unless they are quote unquote, I'm going to call a professional e-bike person, that they understand you have to actually stop pedaling for it to stop engaging. That I'm more concerned about people riding those bikes than a cyclist, because that cyclist has plenty of experience and knows what to do and not. A lot of times we're putting people on it, they're pedal assist, they haven't been on a bike in a while. It's not a good, but anyhow, just for full disclosure.
Fair, yeah, fair enough.
Thank you.
Good afternoon, gentlemen. Sorry, I was out of the room meeting with somebody. I just need a clarification. It says unless prohibited would be that new language. So I'm a little worried about all the jurisdictions that have not actively prohibited. So, or how we'd get the word out. So all of a sudden, people are biking on sidewalks where Senator McCrae's well-founded concern about the elderly, people that are not stable. I live in a town with a lot of encouraging, please walk our town. We dedicated our sidewalks to this walking tour, and we would not want bikes on it, honestly. So I'm just wondering about, unless prohibited, I don't want jurisdictions that, don't spend their lives online studying what we're doing, to get caught in an odd spot where they were like, oh, now we have to actively prohibit to get ourselves out from this bill, the old opt-in, opt-out kind of thing. So what would you say to that concern?
Well, we haven't talked to them this session, but last session we worked very closely with Mako on this, and they were neutral on it, but absolutely.
Well, that's not a good sign.
No. I think we could have talked to them about coming out for it. It just wasn't on their priority list, but we got them to the place where they were absolutely okay with it. And they would, because they would be able to notify their membership, they could,
but this isn't just camp. I don't mean to interrupt, but I just don't want to, I want us to go a little
right.
quicker.
Yeah, but we
Not
also talked
so
to
we have,
MML.
right, we have
Yep.
MML. And then in my county, we only have 3, some counties they're overwhelmingly town oriented. Most of my county is not town oriented, right? So lots of different communities. So
yeah.
I think we want to hear from MML. I'd like to hear from Mako, and I'd like you all, not now, just get back to me on what would you say to me about if the language as drafted would kind of put an affirmative obligation for every little nook and cranny of the state to have to spend a lot of time, voting on this. You've got to then pass a law, a statute. So just get back to me. Let's not do it now, though. Thanks. Thank you, Mr. Chairman.
Thank you very much, Senator James. Seeing no further questions from the committee, thank you very much, Senator, and thank you to the panelists. Good to see you both. So that'll conclude the testimony for the proponents of the bill. We'll have the opposition come on up, and Mr. Titus.
I printed out my color table, if I could just give it out.
Sure, well, if you put it there, we'll have committee staff come and get it, and we'll distribute it. Thank you very much.
Thank you. I'm Jim Titus from District 24. I don't have a problem with the bill as far as ordinary bicycles are concerned, but e-bikes are heavier. They're 3 times as fast, and if one of them runs into a pedestrian, it does so with 10 times the kinetic energy of a regular bicycle. They're more likely to get into crashes with pedestrians because they're faster, and it's actually more dangerous for an e-bicycle to be on a sidewalk than it is for a regular bike, because drivers coming out of driveways or cross streets are not looking for a vehicle coming from their right side at 25 miles an hour. The logic for this bill, which make some sense of reversing, of creating a general rule, a different general rule does not apply to e-bikes. Yes, maybe it's true that a lot of these counties that never thought about the matter would be okay with a new rule saying it's now legal to ride on bikes. After all, we've had 50 years. People have been riding on these sidewalks anyway for 50 years, regardless of the law. But e-bikes are new. They're growing. They're more hazardous. We don't yet know whether it will be safe for e-bikes to be on all the same sidewalks that we're allowing regular bikes. My table has the impact of this bill on every jurisdiction. And if you look at that table, the green right, you'll see that about 50, this bill legalizes bikes on about 55% of the sidewalks in Maryland, but it legalizes e-bikes on 98% of the sidewalks. Baltimore has already outlawed regular bikes on sidewalks, but this will legalize e-bikes on the same sidewalks where ordinary bicycles are illegal. Therefore, I would urge you to amend the bill. I provided the text so that it at least leaves the law the same for e-bikes. Thank you.
Excellent. Thank you very much, Mr. Titus. Thank you for hanging in there with us. Questions from the committee? All right, seeing none, that'll conclude the hearing for Senate Bill 77. We'll now go to our final bill of the day, which is Senate Bill 55. Senator Smith, take it away. Thank you. I know we got a lot of witnesses on this one. All right, good afternoon or good evening, or whatever we're doing here. Senator Smith, here on behalf of Senate Bill 55. I first want to thank Delegate Griffith, who actually brought this to my attention and was the driving force behind this bill for the last couple of years. We ran out of time on this and didn't get through both chambers. So I'm here reintroducing it. Essentially, this bill lowers the threshold for a veterans disabled plate from 100% to 99, from 50 to 99%, that you'd be eligible to have that plate. So right now, the statute reads that you have to be 100% service-connected disability to have that plate. This just lowers that threshold again, so that folks that are 50% to 99% are qualified. This is important because a number of our service-connected disabled veterans are not 100%, but that gap actually has some significant disabilities, TBI, PTSD, to name a few. And so this just opens it up for that process. It doesn't change the fee structure. It doesn't change the class of car or vehicle or license that is eligible. This bill is supported by the Department of Veterans Affairs for the state of Maryland. Secretary Woods has submitted a letter, which is in your bill file. Also, the Maryland Military Coalition has also supported this, and I have a forthcoming request from the Veterans Caucus that I suspect will support this as well. Just to give you some context, according to the Maryland Military Coalition, there are 42,000 service-connected military veterans in Maryland that have between that 50% and 99%. So this is a good bill, pretty simple. That's what the bill does. I ask for a favorable report, and I'll stand for questions.
Thank you, Mr. Chairman. Any questions for the chair? Can we do this like old finance? Can we have a motion? No,
Motion.
No motion. No.
We'll get on the bill. Yeah, we'll get on. Yeah. Right.
Okay.
Just a
Hey.
clarification, co-sponsors are requested voting sessions.
Yeah, we'll do it. Yeah, we'll make sure, we'll drop an amendment for folks that want to get on it. Again, shout out to Delegate Griffith, though, because he's put a lot of work into this over the last couple of years. And so it's an honor to work with him on that.
Thank you, Mr.
All right.
Chairman. Seeing no further questions, that ends the hearing on Senate Bill 55 and ends our hearings for today.